All right, welcome back. Hello, commissioners, and hello, Colorado. This is the Colorado Energy and Carbon Management Commission. It is August 16th, and we are back in action with our business agenda. We will now take up docket number 2304-00117, a proposed financial assurance plan by the applicant KP Kaufman Company. Looks like we need to elevate some lawyers to the panel. So if we could bring in Mr. Jacobs and his colleagues, Mr. Sura, Mr. Lewis Scott Preston, or Stephen Lewis Prescott, butchered that, sorry about that. And we have Mr. Boudreau on behalf of staff. If the other three lawyers could visualize yourselves, we'll get started. Okay, let's have entries of appearance. Mr. Jacobs.
Good afternoon, Mr. Chairman. John Jacobs with Davis Graham and Stubbs, counsel for KP Kaufman Company, Inc. With me today is my colleague and associate Cole Killian and general counsel for KP Kaufman, Ross Wattsman.
Great, thank you. Mr. Stephen Lewis Prescott.
Thank you, Mr. Chairman. Thank you, Commission. Stephen Lewis Prescott from Hammer, Rodriguez, Ostrander, and Prescott on behalf of the City of Tacona.
Very good. Mr. Sura.
Yeah, this is Matt Sura, special counsel for the town of Frederick. Thank you.
And Mr. Boudreau.
Yes, Benjamin Boudreau from the Colorado Attorney General's Office on behalf of ECMC staff.
Okay. Okay, we've got a few, I think to start, we've got a few procedural matters that we should take up. We did receive late last night a motion to vacate this hearing. I'm going to take that up here in a second. In reading the motion in paragraph 20, it appears that the Tacona, Frederick, and staff do not agree with the motion. Mr. Jacobs, as a preliminary thing, I had a few legal issues identified that I wanted to address, but one of them is, I think, maybe dealt with in your motion, which is that it appears that your client is has agreed to not bring some of the issues at this point in time, and in particular the issue around salvage value, and that it appeared that your client would like to take that up at a later date. Is that accurate?
That is correct, Mr. Chairman. We would pursue a 701B form of financial assurance hearing separately, addressing our proposed use of a security interest in personal property against the value of our equipment in partial satisfaction of single well financial assurance.
Okay, so that eliminates one of my legal issues. I was going to have some argument on salvage value, but we're going to hold that for another day. And with that being the case, there will be no evidence or testimony on the issue of salvage value or cost of salvage value or anything like that. Is that accurate, Mr. Jacobs?
I believe that is accurate, and we'd prefer to only present that to you all once, and I'm sure you would prefer that as well.
Yeah. Unless any of my fellow commissioners have any concerns, we will accept the drop of the salvage value as an issue, and that will be taken up at a later date on its own. And so I'm directing the other parties as well that in order to sort of streamline the case a bit, we will not take up the issue of salvage value, whether it is something that the commission should do, and or if so, what the values are, and that'll be done at a later date. Okay, my second question before I get into my legal issues, and now I have two, is to the town and the city. I forget who's who. One of you's a town and one of you's a city. Are you planning on pursuing the argument that the commission has the authority to order plugging and abandoning of wells in a financial assurance hearing today? Mr. Stephen Lewis Prescott, I'd like to hear from you first.
On behalf of the City of Tacona, the answer is yes.
Okay, and then Mr. Sura?
Town of Frederick is not pursuing that today and has not asked for that in its requested relief.
Okay. So I think what I'd like to do now, then I've got two procedural issues before us. One is the motion to vacate. And then the second is whether the commission may order KPK to P&A Wells in this financial hearing, in a financial hearing or a consideration as opposed to a Rule 211 consideration. And what I'd like to do, and commissioners, I'm just trying to move through this. If anybody has a concern about where I'm going, just raise your hand. But what I'd like to do is to give each party, let's say 3 minutes on kind of oral argument on each of those two issues. Mr. Sir, you may not wish to pursue oral argument on the P&A issues since that's not something you're looking for, but I want to do them sequentially. So let's start with the motion to vacate that was brought by Mr. Jacobs. If everybody's comfortable with this approach, I'd like to give oral argument on the motion to vacate, 3 minutes aside, and then the commission will deliberate on that motion before we proceed to the second legal issue, which is the P&A issue. And then after that, we'll get into cases in chief. And hopefully through this, we'll have identified what the final issues for consideration today are. Mr. Jacobs, you're recognized.
Thank you, Mr. Chairman. Commissioners. After the commission initially denied KPK's demonstrated costs, KPK supplemented its Form 3 financial assurance plan with a significant amount of new information. This resulted in ECMC staff changing its position and recommending that the commission approve KPK's financial assurance plan with demonstrated costs of $39,640 per well. Thereafter, ECMC staff and the relevant local government or RLG parties came to an agreement that the RLG parties would voluntarily withdraw their 211 claims without prejudice, as these are best suited for a separate hearing. The RLG parties previously sought an order requiring KPK to P&A all wells within their jurisdictions. The RLG parties, or at least the city of Dacono, as we've clarified here, continues to seek an order from the commission requiring KPK to P&A all of its wells in that jurisdiction, despite withdrawing its Rule 211 claims. The RLG party, city of Dacono, seeks this relief based on sparse language in the financial assurance SBAP at page 65, language referring to deadlines in financial assurance rulings and orders that is specific to the government, to the commission, and not to local governments. There is simply no standard against which to weigh this claim by Dacono that this commission may grant the requested relief in a financial assurance hearing. The city of Dacono nor the hearing officer has provided any applicable standard to be met by the city of Dacono in requesting that extraordinary relief. Rule 702B1CI states that if the director denies an operator's initial financial assurance plan, the operator may file an application for a financial assurance hearing pursuant to 503G11, and that only CDPHE, CPW, or a relevant local government with jurisdiction may file a petition to participate formally as a party in the financial assurance hearing. ECMC staff has approved KPK's demonstrated costs. Therefore, there is no longer a denial of KPK's financial assurance plan, a condition preceding to the city of Dacono's participation here, as well as the town of Fredericks. If ECMC staff would have accepted KPK's financial assurance plan as supplemented from the outset, there would be no financial assurance hearing and the RLG parties would have no basis for participation. The issue of KPK's demonstrated costs should therefore be moot. The remaining issues being KPK's assertions regarding equipment salvage value, which will be heard later, and the RLG parties under Rule 211 regarding a P&A order for wells in their jurisdictions, which also can be heard later under Rule 211. The RLG parties and city of Dacono's claim regarding P&A wells pursuant to this financial assurance hearing based on sparse language in the SBAP and an undefined standard should not be heard in this hearing. This overlaps with the RLG parties 211 claims and is really getting 2 bites at the apple. The city of Dacono really no longer has standing to participate in this hearing because ECMC staff has approved KPK's demonstrated costs. Previously, ECMC staff and the respondent operator agreed upon the appropriate amount of financial assurance. And for other operators, staff has vacated their financial assurance hearings. Here, staff has previously vacated financial assurance hearings even after third parties have been granted party status. That was in the case of Prospect Energy back in May. Consequently, the commission should vacate this hearing, allowing the RLG parties one bite at the apple to argue their P&A claims in a separate Rule 211 hearing, and allowing KPK and ECMC staff to determine the appropriate form of financial assurance in a separate hearing pursuant to Rule 701B. Thank you.
Okay, thank you for the oral argument. To the other parties, to be fair, I'll also give you 4 minutes and 7 seconds, which is the time that was just utilized. Let me hear from staff next.
Thank you, Mr. Chairman. So Mr. Jake has addressed a couple of things there, including Dacono's request for an order that KPK plug and abandon wells. Staff takes no position on that issue. However, staff did file this application specifically to get an order from the commission that KPK post their financial assurance within 90 days, and that is still a valid request. While it is accurate that the director has dismissed other financial assurance hearings, in those cases had a very different posture than this one. Previously dismissed financial assurance hearings were dismissed under Colorado Rule of Civil Procedure 41A, and 41A is not available here because Dacono and Frederick have been granted party status and they filed responsive pleadings. In the previous case that Mr. Jacobs mentioned, Prospect, I believe that's not quite accurate that the relevant local government was granted party status. I believe the status of that case was that the relevant local government had filed a petition for party status, but that party status had not been granted. But regardless, in every case in which the director has filed notice of dismissals for financial assurance hearing, the director already had an approved Form 3 in hand before the matter was dismissed. Thus, the 90-day clock to post the financial assurance was already running. In all of those cases, the operator filed a subsequent Form 3 without demonstrated cost, which was then approved by the director before the dismissal. And we don't have that here. The director cannot agree to dismiss anything until there's been an approved Form 3 and the 90-day clock starts ticking. ECMC is statutorily required to ensure that operators post their financial assurance, and that's what we're here to do today. Therefore, the director respectfully requests that the commission deny the motion to dismiss or vacate and proceed with this hearing as scheduled. Thank you.
Thank you. Mr. Stephen Lewis Prescott.
Thank you, Mr. Chair. And to be clear, Dacono did file a written response around 5 p.m. last night. I want to make sure that that made it into the commissioner's folders and was reviewed.
I apologize if it was filed. I didn't review it. So maybe some of the others did, but let's just hear from you today right now, if you don't mind.
Okay. I will note that there are probably about 10 references to the statement of basis of purpose related to plugging and the commission's standard related to plugging and the commission's objectives and financial assurance plans. So I can't read through all of those in 4 minutes and 7 seconds. I do ask that you consider that response and review it during or prior to deliberations, so that we can clarify that we're not looking at one single sentence in the statement of basis and purpose for being here. Regarding standing, 507A, a party who has been and may be aggrieved should KPK not be financially capable to fulfill its obligations under the act and the rules. Dacono is that party. They have been aggrieved and may risk being aggrieved in the future, absent sufficient financial assurance. Clearly, there is standing here for Dacono to participate and continue participating. KPK has more than 70 wells in a 9 square mile city of Dacono. 13 have experienced spills in the past 3 years, and 59 have little to no production. They are apparently liabilities on KPK's books and something that Dacono has to deal with on an ongoing basis. Under Rule 702B1C, it expressly grants local government standing in financial assurance proceedings when the initial Form 3 has been rejected by staff. That's exactly what happened here. KPK's initial Form 3 was submitted in November. It was rejected by staff in March, and this docket was created. So lastly, Dakota was formally granted party status by the hearing officer on June 1st, as Mr. Boudreau stated. We're part of this case. There's really no basis for vacating this hearing. Staff still seeks an order. It still has to proceed. It's not clear that the salvage value issue, which all the parties dispute, has actually been resolved. It sounds like they're just asking you to take it up at a different time, but still apply it to this hearing. So it's still a disputed issue, whether or not KBK wants to talk about it today or at a later date. KBK's reference to us pursuing 211 is a red herring here. Dakota is not seeking plugging of the issue wells into Dakota pursuant to Rule 211. Dakota is seeking plugging as part of the financial assurance plan approved by the commission pursuant to the 700 rules and the financial assurance rulemaking statement of basis and purpose, which clearly state the commission may require wells to be plugged as part of a financial assurance plan. And again, I refer you to Dacono's response to the motion filed around 5 p.m. last night. Again, there are about 10 or more citations to the statement of basis and purpose discussing plugging and what your objections are, and gives you guidance. The commission must determine whether the operator is financially capable to fulfill its obligations under the Act and the rules. In this instance, the question for the commission is whether KPK is financially capable of remediating spills at the issue wells in Dacono, remediating unknown spills, plugging and abandoning 59 wells, and reclaiming those well sites under the proposed financial assurance, and whether plugging is the preferred option as opposed to bonding, given the risks that those wells show and the risk that KBK has shown with regard to its current finances. The commission must also determine the risk threshold for an operator with respect to the likelihood that an operator will fail to timely plug and reclaim a well, thus allowing it to fall to the taxpayers in open well fund to cover the costs. These are the standards that are applied. Reading the statement of basis and purpose doesn't leave open the question of what's the standard for when plugging is appropriate in a financial assurance plan. It's all there. It's very clear. Plugging and a deadline by which to plug wells is very clearly contemplated in the statement of basis and purpose and in the rules themselves. So Dacono certainly has standing and is correctly here requesting plugging instead of bonding for wells if they can meet that burden to show that KBK is not financially capable of meeting its obligations. And there's a legitimate risk to taxpayers if these are not plugged immediately and instead are bonded. You know, the bond as proposed by KBK is a 10-year bond paying 10% of what we believe to be much too low of a cost. And that's also why we are here. We're seeking relief related to those 59 wells in Dacono. If they're not going to be plugged, we're going to put on evidence showing why that single well financial assurance for those wells needs to be much higher than $39,460. The point is this: once Dacono is granted party status, it requires a stipulation among all the parties to dismiss this case or vacate the hearing. We're properly here before the commission, and we're entitled to refute any party's position with respect to whether the wells should be plugged or bonded, and as with respect to the amount of bonding that should go with the wells. Thank you.
Okay, thank you very much. Mr. Sura, on behalf of the town of Frederick.
Matt Sura, on behalf of the town of Frederick, thank you. The town of Frederick agrees with everything just stated by the city of Dacono. And for the record, although we are not taking a position in seeking wells to be plugged and abandoned in this hearing, we do believe that it's an appropriate part of any financial assurance plan that they look holistically at their portfolio of wells and decide from the outset and tell you from the outset what wells they intend to continue to produce and what wells ultimately they think should be on the out of service well list. And if they can't demonstrate that, that should be a red mark or a concern for any proposal that's being evaluated. To be clear, KP Kaufman misrepresented the position of the town of Frederick. I would like to get into the record that the town is requesting relief that includes a full single well financial assurance of $30,000 per well for plugging and $100,000 per location for reclamation be required As an alternative, the town of Frederick is going to support $32,000 for plugging costs and $85,000 for reclamation. We can prove that for the 107 wells within the town. And I'll additionally request additional bonding be pursued in the coming months for remediation projects in Frederick through 707 staff analysis. Just to step back for a minute, KB Kaufman is going to argue that there's no need for a hearing because the parties agree on all issues, pertinent issues. And that's just not true. The parties don't agree on any of the issues. And it should concern you that KP Kaufman is saying, look, we have staff confirmation that our $7,800 is adequate reclamation bonding, and therefore there's nothing to see here. Let's move on. We've put a lot of evidence in the record and are intending to present evidence today at this hearing that that's not even close, that the information that they've provided is completely inadequate and that reclamation cost is going to be inadequate, leaving both ECMC and Colorado taxpayers in the lurch. So ultimately, you have the ability as a commission to at any time on any issue, bring something up before you, whether this was agreed to by the staff or not, whether it's coming to you today or not, you have the ability to require a hearing through 503A. And, you know, in your position, and on behalf of the town of Frederick, I hope that you are interested in hearing the arguments that we've put forward in the record and we're prepared to put forward today at the hearing. Thank you.
Okay, thank you for the argument. Commissioners, we just ensured that the that the city of Dacona's response is in your email box. If we like, we can take a short 10-minute break and have folks read that. I frankly am ready to provide my thoughts on the motion to vacate now, without the necessity of reading it. But I want to acknowledge if anybody else desires to take a look at that and we could take a break.
Mr. Chair, I had the opportunity to read it when it was presented last night, so I'm good.
Okay.
I also reviewed, so I'm good.
All right. I'm the only one that was delinquent. Apologies for that. At any rate, with regard to the motion to vacate, I am in favor of denying the motion. I think for a couple of reasons. One, I do believe the local governments have automatic standing under Rule 507A. I believe the local governments, in particular the town of Frederick, is challenging the financial assurance numbers. And I just heard from Mr. Lewis Prescott that his client is also challenging the actual numbers with regard to financial assurance. I believe those issues at a minimum are before us, and I believe that the parties ought to be heard on that. Finally, I agree with Mr. Sura that under Rule 503A, we can bring something before us. I think this matter needs to be before us. I think we need to hear it. And I am in favor of denying the motion to vacate and allowing the hearing to move forward on the singular issue of the actual amount of financial assurance through demonstrated costs or through otherwise. So those are my initial deliberative thoughts. Do other commissioners desire to weigh in on this first issue with regard to the motion to vacate? I also would note that the issue of salvage value is not before us today. And so if we move forward, we would not be having any argument, testimony, witnesses on the salvage value issue. And if KPK desires to bring that up, that would be at a future date. So those are my thoughts. Others with deliberative thoughts, Commissioner Cross.
Thank you, Mr. Chair. I'm in agreement with you. I think, first of all, as you stated, under our rules, there are several different places where it's clear that relevant local governments may petition to be parties within an application before the commission. That has happened here under the 500 series. I think that matches under 70, I believe it's 702A that also, or 702B, I'm sorry, I think that matches us there as well, because this is something that was initially denied by the director, and therefore they can proceed as a party in that manner. I also wanted to highlight, I agree with Mr. Boudreau's analysis that given that there is still a denied application out there and there hasn't been an approved application, we can't just merely set this aside and move forward with it. We still have a right to hear about it as commissioners, to review it. And given the, I'll say, increased activity going around this financial assurance application, I think it's appropriate for it to come before the commission and us to hear all evidence with respect to the demonstrated costs, even setting aside the salvage value and other issues for right now.
Thank you. Further deliberative thoughts from commissioners? Commissioner Messner?
Thank you, Mr. Chair. Thank you both for your deliberative comments. I would concur with you. Only one other point I would bring out is that in addition to 503A, the commission certainly has the ability to utilize 707B22, which at any time the commission may commence a financial assurance hearing for an operator on its own motion. And so I find it the determination of denial of this motion is appropriate.
Great. Commissioner McGowan, Commissioner Ackerman, anything to add?
No, Mr. Chair, I'm in agreement with your statements.
All right, I would move to deny the motion to vacate. Do we have a second?
Second.
Motion and a second. Further discussion? All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Okay, motion to vacate is denied. Next, I think we still need to have, or at least I would like to hear from the lawyers, because there is legal differences of opinion with regard to whether the commission can order plugging and abandoning of wells in a financial assurance application. I do know that we have that authority under Rule 211 under the used and useful parameter. But I'd like to clarify that issue, and I'd rather do it via some oral argument now, as opposed to hearing testimony, et cetera, around the initial issue of legally what's our issue here. So I believe I will call upon Mr. Stephen Lewis Scott, who sort of brought the issue to bear first. Try to keep it at 3 minutes, and then we'll move through the rest of the attorneys. Thank you.
Sure, and may I ask permission to share my screen? The references to the statement of basis purpose I did include in the PowerPoint presentation I intended to provide. So it'll be part of my opening statement, and it's direct quotes that I would like you to see.
Yeah, that'd be perfectly fine. And we'll hold off on the clock until you can get yourself prepared.
Thanks so much. All right, I assume you can see my screen.
Yes, we can.
All right, going to the statement of basis and purpose for the financial assurance rulemaking dated March 1st, 2022. I pulled direct quotes that talk about what we're doing here and why plugging is available to the commission as part of a financial assurance plan. Page 1. The intent of the financial assurance rulemaking was to set rules to make sure that every operator is required to provide assurance that it is financially capable of fulfilling every obligation imposed by the Act. Going to page 4, Rules 434 C and D, the Commission adopted comprehensive new standards to require and incentivize plugging of inactive wells, including some financial assurance requirements. We're connecting financial assurance to plugging and incentivizing plugging. Going to page 59 of the statement of basis and purpose. Now, I'll simply summarize in respect for time. This is really talking about the different options for financial assurance. KPK has submitted under option 4. To summarize this passage, Option 4 is the highest risk operator. And page 62, I'll summarize again. Again, option 4 is the highest risk operator, highest risk of not fulfilling its liabilities with respect to plugging and reclamation. Going to page 63, option 4 operators may receive a credit for plugging and abandoning wells, but not for plugging, abandoning, and reclaiming out of service wells on the operator's plugging list. Only 7 of the 59 wells Dacono has identified as the issue wells in Dacono, which, by the way, is not all of KPK's wells. Dacono specifically focused on those wells that, for lack of a better word, are not profitable, are losses on the books for KPK that should be plugged as opposed to bonded. And this is expressly contemplating, aside from those 7 wells that KPK did put on its inactive list, the other 52 wells KPK can get a credit for if they plug them, i.e. KPK can lower its financial assurance requirements, which I think it will deem necessary, by plugging wells. KPK benefits from plugging wells. According to KPK and its salvage value in its presentation, KPK makes money when it plugs wells. So we're looking at what's best for everyone and how do we get to financial assurance that makes sense. Plugging wells, according to KPK, makes sense. Go to page 64. It more or less repeats the really intent and purpose of financial assurance, ensuring that the operator can fulfill all of its obligations under the Act and the Commission rules. Ultimately, the Commission chose a definition of single well financial assurance that promotes ease of administration and certainty for operators and stakeholders, minimizes the risk that taxpayer orphan well program funds will be necessary to plug, abandon, or reclaim wells. Again, that's the standard that we're playing by. Are they financially capable to fulfill their obligations? What is the risk that the taxpayers and the orphan well fund will be left to plug and abandon the wells? And is plugging the answer to ensure that these 2 things are considered? Page 65, it talks about deadlines, specifically deadlines in a financial assurance plan for plugging, abandoning, remediating, or reclaiming specific oil and gas well locations and facilities. We're not asking for deadlines to plug all of the wells. We've identified specific wells, and it expressly right here, a financial assurance plan can provide for deadlines to plug specific wells. That's what we're asking you to do. And those are my references to the statement of basis of purpose. I also referenced 702 under the option 4. There is reference to giving credit for wells plugged in a financial assurance plan. So I think the rules and the guidance we get from the statement of basis and purpose make very clear plugging was contemplated to be part of financial assurance plans, and in this case, as we will show, should be part of a financial assurance plan. Thank you.
All right. Thank you for the oral argument. You set the bar at 4 minutes and 25 seconds. Mr. Sura, did you want to be heard on this issue?
No, Chair. I think, again, would like to just reiterate that the town of Frederick does support the argument made by the city of Dacono.
Okay, that's fine. Thank you for streamlining that. Mr. Boudreau, did you desire to be heard on this issue?
No, Mr. Chair. Staff takes no position on this. And yeah, thank you.
Okay, thank you. Mr. Jacobs, you have 4 minutes and 25 seconds.
Thank you, Mr. Chair. Commissioners, I would start by pointing out that statement of basis and purpose is intended to clarify existing rules and the intent of the commission in promulgating them properly. There is no rule allowing the commission to force plugging orders under the 700 series. That option was available to this commission during rulemaking, and instead, the commission chose to include that in Rule 211. That relief is available to the city of Dacono through a 211 hearing that they expressly intend to seek by a separate petition. They cannot now create a new rule. You and the city of Dacono, at its urging, cannot create a new rule that was not properly drafted and noticed and then promulgated during rulemaking. Additionally, Dacono's response to our motion attempts to discern an articulable standard from myriad snippets of SBAP text that you've just seen on several slides posted by Mr. Lewis Prescott. Dacono provides that the SBAP repeatedly contemplates plugging of wells as part of a financial assurance plan, but it does not constitute an articulable standard, and it would be arbitrary and capricious for the commission to forcibly require KPK to P&A its wells without first providing a standard against which the city of Dacono's claims can be weighed. That can be done in 211, and it can be done after establishing the amount of single well financial assurance in this proceeding. So the relief requested by Dacono is not denied, it is only deferred by such a ruling. And I urge you to make such a ruling to preclude the decision on a P&A order as part of this financial assurance hearing, and to limit the testimony and evidence to the proper amount of single well financial assurance, which has been accepted and recommended by the director in KPK's favor, relying or using demonstrated costs. Thank you.
All right, thank you. So I'll thank you to the attorneys for providing oral argument on this issue. I guess I'd like to ask Mr. Stephen Lewis Prescott a question, and I'm going to preface it with this commissioner's thought, belief, et cetera, is that plugging, abandoning wells is a good idea and should be done and is part of an operator's work in the state of Colorado. But I'm struggling to find, I mean, and I appreciate you provided a bunch of SBP language, but as I look at that SBP language, I don't see that there is a rule in the 700 series or otherwise that allows us to force upon an operator a plugging and abandoning commitment as part of their financial assurance plan. Again, it could be a good idea and the operator could voluntarily put that as part of their financial assurance plan, and that could be taken into consideration. But I'll give you one more shot because this will it is an important issue, and I don't want the commission to get this wrong. I also would appreciate AAG Davenport getting ready to weigh in on this and provide some legal advice to us. Mr. Prescott.
Thank you, Chair. I think looking at the financial assurance rulemaking and the purpose of financial assurance plans, the commission is tasked with a relatively difficult decision process related to ensuring that we have sufficient financial insurance. And the presumption is certain amounts per well for a 10-year payment period. And the question is, and I think the reason that the door was plainly left open in consideration of what a financial assurance plan should involve and whether it can involve plugging wells, is to ensure that financial assurance is sound, that the operator is going to take responsibility and be liable for its wells, that it's not going to fall to the state or the taxpayers to cover. So in situations, I'm not saying that it's common, but I think there are unique situations where plugging is necessarily a consideration, is necessarily part of a financial assurance plan. And the statement of basis and purpose put everyone on notice of this. No one's surprised. It clearly lays out what the purpose of a financial assurance plan is. And it's to ensure that the companies are financially capable of meeting their obligations so that the state and the taxpayers don't have to. And in this case, we plan to present evidence showing that absent some plugging of wells, we're going to have major issues. And the commission can determine that this is not the right situation for plugging if it so deems. But given the clear contemplation for plugging in the statement based, we wouldn't have been here but for reading the statement of basis and purpose and understanding that plugging was part of a financial assurance plan. So frankly, I think it was sufficiently noticed, contemplated, and foreseen as part of the financial assurance process and plans. Thank you for the opportunity.
Thank you. AG Davenport.
Thank you, Chair. In my view, the financial assurance rules do not allow for or authorize the commission to order an operator to plug in abandoned wells when the operator has not proposed to do so. I think if you look at the financial assurance rules in sum, what they do is provide operators with options as to how to deal with their wells and provide financial assurance that shows that that operator is capable of meeting all of their obligations. And one way for an operator to do that is to declare wells to be out of service and put them on the plugging list. And I believe that the state reference to the deadlines to do that in the statement of basis and purpose was to that end, where an operator proposes to put wells on a plugging and abandonment list, and the commission or staff approves that financial assurance plan, it's appropriate to put deadlines on that plugging abandonment in that context. But where an operator proposes to do something else with the wells to provide single well financial assurance, for example, for those wells, and the commission is satisfied that that single well financial assurance amount is the right amount, the commission does not have the authority in a financial assurance hearing to then, over the operator's objections, order plugging and abandonment of some or all of the operator's wells. That, in my view, well, a little bit further, there are other instances where the commission orders plugging and abandonment as an option. For example, in a hypothetical enforcement case, the commission could say, as a corrective action, one of your options is to plug and abandon a well, but you can also repair that well or do other things with it. In my view, in the only instance that I'm aware of in the rules where the commission can just order an operator to plug and abandon a well where the operator has no other option but to plug and abandon that is through a 211, Rule 211 proceeding.
And just so that our folks that are listening in, the 211 proceeding does what?
The 211, I think, has commonly been referred to as used or useful. A person can apply, if they have standing to do so, for a commission order to order an operator to plug and abandon a well. Either, I don't have that rule in front of me, but I believe it's either that well is not used and useful, or it presents a threat to public health, safety, welfare, the environment, and wildlife resources, or both.
Okay. Okay. Commissioner Cross.
And I don't want to jump ahead here, but I'll just give a couple of my thoughts here. I think I do agree with Mr. Jacobs in the sense that the commission had the ability, when it drafted the revised 700 rules, to put in something that required this. I think Mr. Lewis Prescott is correct that an important aspect of the financial assurance is making sure that an operator has the capability to meet its financial assurance obligations and deal with the full life of the well. And as AAG Davenport expressed there, that can be done through an option of showing, hey, we're going to plug and abandon some wells. But the fact that the commission in other areas of our rules has specifically stated the commission can require a well to be plugged and abandoned, but chose not to do so here, I think is the sticking point for me. That I don't think it's something that is under our purview under the 700 series, but is instead under our purview under the 211.
Commissioner Ackerman.
Thanks, Mr. Chair, and I generally agree. I think, as a bit of a counterpoint, though, I do think that there would be a utility of hearing those arguments, but it would only be useful if the operator stated that they would be willing to hear the merits of those arguments and voluntarily consider them as part of its own financial assurance proposal. In that sense, to me, there would be some utility to hearing the arguments. Otherwise, I would agree that they are likely more appropriate somewhere else.
Commissioner Messner.
Thank you, Mr. Chair. I just want to check to make sure I'm not echoing anymore.
You are not echoing anymore. Great job.
So I'm gonna disagree a little bit. I think there's certainly an avenue available for impelling an operator to plug and abandon their wells through Rule 211. I think that's a clear path. I think that's one that was overtly contemplated in the financial assurance rulemaking. And I think that's probably the most effective mechanism for encouraging an operator or requiring an operator to plug and abandon a well after a hearing. I think a lot of the rules regarding financial assurance talk about the option of an operator developing an out of service plugging and abandonment well list, and that is a tool that's available to an operator to utilize in order to minimize their financial assurance obligations, and also plug and abandon a subset of wells in a timely fashion. That was contemplated as a tool to be utilized. But I think what I'm hearing the city of Tacona argue is that this operator may or may not be financially capable of meeting its obligations under the act as required by a financial assurance plan, and is presenting an alternative to the operator in providing options to potentially remedy that should that argument be found valid. I don't have an opinion right now on this. I think where I'm struggling is I think that this should actually be argued in the breadth of the case in chief and is directly relevant to ultimately what our determination is, which is the total amount of costs associated with this financial assurance plan. And so I would be open to allowing the city of Tacona to continue to make these arguments in their case in chief, in the breadth of the arguments directly related to how it is a possible option in determining whether or not this operator has the financial ability to meet all of its obligations under the act, and what ultimately the financial assurance amount will be associated with the financial assurance plan that this commission will ultimately make a decision on. And so I don't see any benefit to making a determination prior to hearing the case in chief on this docket. So that's just my thoughts.
All right. Thank you, Commissioner Messner. I sometimes relish hearing from a non-lawyer commissioner on these sorts of topics because I think you bring a good perspective to it. I still am uncertain as to whether our rules allow us to compel an operator or force an operator to P&A as part of a financial assurance plan. But as one commissioner, I'm willing to listen to Tacona's witness or et cetera, and we'll make a determination, at the conclusion of all the evidence. Are other commissioners comfortable with that as a solution on this issue at this point? Commissioner Cross?
Thank you, Mr. Chair. And I agree. I'm happy to listen to them talk about it. I think the only negative of doing so is, this could potentially speed up the time if we're not listening to testimony on it, but I'm fine hearing it. I mean, that's what we're here for is to listen to the party. So I'm fine hearing it. But I think ultimately that's my concern. I think that if Mr. Jacobs and KPK is willing to consider it, I think that's great. But I don't know that we can compel it in this hearing.
All right, does any commissioner have anything further? If not, I think we'll proceed with this procedural approach and not rule on the legal authority issue, and instead just let Dacono present its case, and we'll take it up at the conclusion of the evidence. Seeing no jumping up and down, that will be our course of action on the plugging and abandonment component to this.
Mr. Chairman, if I may.
Yes, Mr. Jacobs.
I just want to point out, because it didn't come up, that the relief sought by the city of Dacono, if reserved to 211, is subject to notice requirements that have not been satisfied in this proceeding by the city of Dacono. That would constitute reversible error should you seek to entertain a plugging and abandonment order as a result of simply listening to their case on whether to plug or require the plugging and abandonment of numerous wells within their jurisdictional boundaries. So it is more than simply a willingness to consider what they've prepared for you to hear today. It is reversible error should a decision to plug and abandon or require plugging and abandonment be made and then appealed. I want
Great.
commissioners to understand that. Thank you.
Thank you for the procedural motion. It is noted for the record.
Thank you.
Okay, so I think in summary, we will hold the hearing. We have denied the motion to vacate. We will consider Dacono's arguments relative to plugging and abandoning over the objection that is reversible error. We will not take up evidence and testimony on the issues of salvage value. The hearing will be limited to the consideration of the operator's demonstrated costs, or in the alternative, as other folks have argued, utilizing the 702 numbers or wherever we end up. The last issue, procedural issue I wanted to raise before we get into the merits is with regard to exhibits. The final pre-hearing order, maybe it was other documents, there appears to be parties all with disagreement about the entry of exhibits. I propose that we just take that up at the time. So if a party introduces an exhibit, if anybody has an objection, you'll create your objection and we'll hear from the attorneys, and then I'll rule on the merits of the exhibit admission. I will instruct the parties that this lay commission does understand the objections around hearsay and relevance, and objections in those two areas are going to be frowned upon by the chair, because I think we can weigh the evidence and understand if it's an out of court statement, etc. So be leery of objecting along those lines. AAG Davenport, if you could visualize one last time. Did I miss anything procedurally?
Not anything that I had on my list,
Okay.
Mr. Chair.
I hate to do this, but I'm going to do it anyway. I'd like to ask each of the parties or attorneys if they have anything further procedurally, or if there are any concerns about the decisions that the commission has made and or not made. Mr. Jacobs. You're muted, Mr. Jacobs.
My apologies. Thank you, Mr. Chair. I do have a concern about this approach on admissibility, in as much as the final pre-hearing order says that raising objections and explanations on the basis of objections comes out of our allocated hearing time. I think that's inappropriate. This tribunal is the gatekeeper of reliable evidence. The integrity of these proceedings are your obligation under your own 500 series rules. It should not come out of the hide of an objecting party unless it is interposed for delay or other improper purposes.
Thank you for that. I'm not inclined to, let's just see how it goes, Mr. Jacobs. I'm gonna include objections in time, but if it gets to be, if it appears that this is just more of a delay tactic to rob people of time, I will revisit that. Anything further procedurally from you, Mr. Jacobs, before we get going?
Not at this time, Mr. Chairman. Thank you.
Thank you very much. Mr. Boudreau, anything further?
Thank you, Mr. Chairman. Just a clarifying question on admissibility of exhibits. So to the extent that exhibits aren't specifically admitted into the record by, say, the end of presentations in chief, do parties need to specifically move to have those put into the record?
You mean if
Or-
they've not been objected to, or if you've not brought one up in your case in chief?
Right. If I've not brought it up in my case in chief, but I filed it previously, and I'd like it in the record, do I need to, at the end of my presentation, make a motion to have that included in the record? Or is it
I think
included
that
by
makes
default?
sense. And I think it creates a clearer record, and it provides the other parties with an opportunity to object using some of their time. So yes.
Thank you.
Mr. Lewis Prescott?
Thank you, Chair. No questions or issues, procedural issues on behalf of Dakota.
Mr. Sura?
Thank you, Chair. We're ready to proceed.
Okay, with that, I would note that the final pre-hearing order provided that staff will be allotted 60 minutes, KPK is allotted 120 minutes, Frederick is allotted 90 minutes, and Dacono is allotted 45 minutes. These time allotments are exclusive of questions from commissioners and answers to those questions. Including in these time allotments are objections to exhibits and explanations surrounding those objections. And I'll revisit that if it looks like that's getting out of hand, as I've just previously noted. The order of presentation is opening statements by staff, followed by KPK, Frederick, and Dacono. We then have staff, case in chiefs in the following order: staff, KPK, Frederick, Dacono. We then have rebuttal, staff, KPK, Frederick, and Dacono in that order. We then have closing argument, KPK, Frederick, Dacono, and staff. Does anyone have concerns with that order of play? Mr. Jacobs, you have your hand up.
Yes, I'm okay with the order. I do wish to ask for 5 or 10 minutes to edit my opening statement in light of your rulings here, eliminating salvage value and other issues.
That's an excellent suggestion. Let's take 15 minutes and return at 2:14.
Thank you, Mr. Chair.
All right, welcome back. This is the Colorado Energy and Carbon Management Commission, August 16th hearing date, and we are taking up docket number 230400117. We have dealt with procedural matters. We have also heard from the public this morning as part of the docket. And we now are going to start the hearing with opening statements. And again, each party is to be aware of the time that has been allocated. Hearing Officer Elias Thomas, who's with us, will be keeping track of time. At any point, if anyone desires to have a time check, just let us know and give him a minute or so to determine time. And so with that, we're going to hear opening statements starting by staff.
Thank you, Mr. Chair and Commissioners. We're here today for a financial assurance hearing involving KP Kaufman Company, Inc. The director requested this hearing for the singular purpose of having the commission review KPK's financial assurance plan. At the end of this hearing, staff will respectfully request that the commission enter an order that KPK post their required financial assurance within 90 days, as is required by the Oil and Gas Conservation Act and ECMC rules. Today, you'll hear testimony from Deputy Director Scott Cuthbertson, in which he will outline the process for reviewing Operators Form 3 financial assurance plans. That process for review is reasonable, and the Deputy Director applied that process consistently for all operators who propose demonstrated costs. You'll hear the Deputy Director testify that KPK's initial financial assurance plan proposed to use demonstrated costs for single well financial assurance. You'll also hear him testify that upon reviewing KPK's initial financial assurance plan, he denied that plan because KPK provided insufficient information to support their initially proposed costs. After the deputy director denied KPK's initial Form 3, the director filed a notice and application of hearing. In that application, the director requested that the commission enter an order that KPK implement its Form 3 plan, but without demonstrated costs. However, on July 1st, 2023, KPK updated their proposed demonstrated cost and submitted supplemental documentation to support those updated costs. The deputy director reviewed KPK's supplemental filing pursuant to the same review process he applied to every Form 3 which proposed demonstrated costs. The deputy director concluded that KPK's supplemental information provided a reasonable foundation for KPK's updated costs. Those updated costs are $31,626 per well to plug and abandon the wells and $8,600 per location for reclamation. When broken down into single well financial assurance, in other words, when one does the math to account for the fact that some locations have multiple wells, KPK's updated total single financial well assurance is $39,460 per well. That includes P&A and reclamation costs on a per well basis. Today, staff is still requesting an order from the commission that KPK post the required financial assurance within 90 days. However, now staff requests that the commission use KPK's updated demonstrated cost to calculate that financial assurance obligation. Now you're going to hear you're going to hear arguments from Dacono that the commission should order KPK to plug and abandon certain wells within that jurisdiction. And staff takes no position on that issue. But regardless of how you decide that issue, or if you decide that issue, nothing precludes you from entering an order that KPK post the required financial assurance. You'll also hear arguments from Dacono and Frederick that KPK's updated demonstrated costs are insufficient to cover KPK's obligations. The director disagrees and maintains that the supplemental documentation KPK submitted provides a reasonable foundation for KPK's costs. And if, in the future, KPK's demonstrated costs change, the rules allow ECMC to amend KPK's financial assurance accordingly. But again, regardless of how you calculate KPK's financial assurance obligations, whether that's with or without demonstrated costs, nothing precludes you from entering an order at the end of this hearing that KPK post the required financial assurance. Furthermore, these financial assurance plans are subject to annual review. In the annual review, staff would of course account for any factors the commission orders staff to consider. But that annual review cannot begin until there is an approved financial assurance plan in place. And that is one of the reasons why the director is so adamant that the commission approve a financial assurance plan at the end of this hearing. Ultimately, the director's requested relief is simple, that at the end of this hearing, the committee enter an order that KPK follow the rules by posting their required financial assurance within 90 days of the order. Thank you.
Thank you. I promise I was listening, but I'm eating a late lunch. So, okay. With that, I believe we have an opening statement from KPK.
Thank you, Mr. Chair, Commissioners. As you well know, this is one of many financial assurance hearings for operators like KPK who seek to use demonstrated costs for purposes of determining the amount of their single well financial assurance obligation. And like an increasing number of operators, staff and KPK have finally come to agreement on the use of demonstrated costs. In KPK's view, as you've heard, that should be the end of this proceeding, a determination of the amount of single well financial assurance that is required for plugging and abandonment and reclamation obligations. But in light of your rulings, we are of course prepared to proceed with this financial assurance hearing. The RLG parties seek to dispute the demonstrated costs already agreed to by the director and KPK. City of Dacono also seeks on a novel theory an omnibus plugging and abandonment order for most KPK wells in their jurisdiction. Yet it has articulated no standard to be met by it in seeking such extraordinary and highly consequential relief. And the RLG parties have both now withdrawn their Rule 211 claims for which they sought permissive joinder in this proceeding, and instead they intend to separately petition for a Rule 211 hearing seeking the very same relief in the case of City of Dacono. In short, City of Dacono seems to be taking two bites at the apple. City of Dacono also pursues inconsistent arguments, on the one hand saying KPK will not be able to afford adequate bonding, and on the other not allowing this process to play out and rushing to seek the forced plugging and abandonment of most KPK wells in their jurisdiction for the clear benefit of private land developers, one of whom you heard from this morning during public comment. And so staff and KPK are on the same side with respect to demonstrated costs. Staff is the applicant with the burden of seeking your approval of the director's recommendation and acceptance of KPK's demonstrated costs. KPK certainly supports staff in that regard and will provide testimony on how those demonstrated costs were developed, consistent with other operators that have obtained the director's approval. And KPK will refute the assertions of the relevant local government or RLG parties that its demonstrated costs are inadequate with respect to reclamation in particular. In that regard, you will hear testimony from KPK's chief operating officer on its remaining reserves and the many factors affecting KPK's current low average production per well, and its production and operations engineer with substantial experience in plugging and abandonment design and project implementation on the manner in which demonstrated costs acceptable to the director were developed for the supplementation of KPK's initial financial assurance plan. You will also hear testimony regarding how the RLG parties have grossly overestimated reclamation acreages by including many other operators and other third parties' roads and facilities, and are seeking significantly higher reclamation bonding for areas being developed for uses inconsistent with ECMC reclamation. Housing and roads, for example. You will also hear how the RLG parties have sought to introduce objectionable evidence in support of their proposed financial assurance and desired omnibus P&A order for most KPK wells within their boundaries in the case of City of Dacono. Reference to the unadjudicated NOAVs not tied to an order finding violation as required by the 700 series and SBAP, and NOAVs that are unadjudicated have routinely been excluded from evidence by this commission, consistent with the Colorado rules of evidence. You will hear their reference to complaints that have not resulted in enforcement and do not even rise to the level of excludable unadjudicated NOAVs. And you will hear their reference to, and our objection to, spills which are not violations in and of themselves, and many of which, among those raised by the RLG parties, are historic in nature, discovered during plugging and abandonment work, and were not an act of release from KPK operations. The town of Frederick even argues that KPK is delinquent in payment of penalties as a high risk factor, but this is absolutely not the case, as penalties assessed by the commission against KPK have been automatically stayed by this commission's own rules pending the appeal by KPK of this commission's prior order of last February in another docket. These submissions are prejudicial and objectionable under the Colorado rules of evidence. They warrant and will be objected to and must be excluded from this proceeding and disregarded by the commissioners in their deliberations. So I ask for your patience as I make those objections during party testimony as required by your ruling. Staff and the director are in agreement on KPK's demonstrated costs. The RLG parties dispute those costs by overestimating reclamation, among other things, and include other operators' roads and facilities, even as they admit many locations will be subject to development that is inconsistent with such reclamation. These efforts by Dacono and Frederick do not appear to be about reclamation that will or should be required and therefore financially assured. Rather, they are more about putting financial stress and pressure on KPK, and in the case of City of Dacono, seeking an omnibus plugging and abandonment order from this commission for numerous wells, most wells with significant reserves and productive life remaining. The city of Dacono seeks for you to do this now so their developers can avoid paying for well plugging and abandonment at customary rates charged by KPK and many other operators, and notably without the procedural protections of eminent domain proceedings or the fair compensation that they require. Those rates to which the RLG parties object have been paid to KPK and other operators by many developers to date, and will continue to be paid to KPK and other operators by some of those developers in the future. And those are private contractual matters that are outside the scope of this commission's statutory authority in any event. Do not be swayed from the purpose of this hearing. A determination of the amount of single well financial assurance for KPK wells. Staff has approved KPK's demonstrated costs after our supplementation, consistent with multiple other operators' approved demonstrated costs that have not proceeded to hearing for your consideration. Be mindful of the RLG party's efforts to have you treat KPK very differently from other similarly situated operators, for doing so is the hallmark of arbitrary agency action. We urge you to accept the director's recommendation on KPK's financial assurance plan and allow KPK and the RLG parties to address the form of financial assurance and the desire for a P&A order for some wells in separate hearings under Rules 701B and 211. I thank you in advance for your careful attention to the evidence and argument to be presented.
Thank you, Mr. Jacobs, for the opening statement. We now will have an opening statement from Mr. Sir on behalf of the town of Frederick.
Yes, thank you, Chair, and thank you, Commissioners. Matt Sir, representing the town of Frederick. The town had intended to use this time to request closure of 95 wells within the town of Frederick that are no longer used or useful under Rule 211 because they produce little to no oil and gas. Frederick believes that the financial assurance regulations require taking a holistic look at the wells in an operator's portfolio. Deciding if and when some wells should be plugged and abandoned is an important part of any financial assurance plan. Commissioner Cross had it right. It is a factor that must be considered. A low producing operator that does not provide for any wells to plug should cause some level of concern. The plans of Civitas and Occidental Kerr-McGee, who also operate wells within the town of Frederick, have proposed to close wells that are no longer productive as part of their financial assurance plans. That is how the financial assurance plans are supposed to work. The town of Frederick also joined as a party to this hearing to support ECMC staff's request for estimated single well financial assurance of $30,000 for each well plugged and $100,000 for the reclamation of each location. All of that changed after KPK submitted some new cost estimates for only 18 of their more than 1,000 wells, and the ECMC staff agreed with KPK's outrageous assertion that well sites can be successfully reclaimed for $7,800 each. As a result, the city of Frederick withdrew its Rule 211 claims and has requested relief that single well financial assurance of $30,000 for plugging and $100,000 for reclamation be required in this case. In effect, the town of Frederick has been placed in the unfortunate position of having to defend the rules in opposition to both KPK and, unfortunately, ECMC staff. To adopt the financial assurance rules, this commission had 16 hearings that spanned over 7 months. The cost of reclamation was discussed and debated for most of that time. It was your staff that offered the most compelling evidence to justify the $100,000 single well financial assurance reclamation cost estimate based on the experience of the orphan well program. Yes, the rules do contain a provision to allow for an operator to demonstrate that it can plug wells for less than the estimated single well financial assurance. But there are important sideboards that were placed in the statement of basis and purpose. Information that the operator necessarily had to supply so the ECMC staff and you commissioners could determine if their numbers were accurate. The town will show today that none of the information required has been supplied by KPK. Their assertion that the cost of reclaiming a well for $7,800 a location is not based in reality and does not comply with your rules. Because they have not supplied adequate information, their demonstrated costs must be disregarded and $100,000 per location should be required. To do otherwise would be in violation of statute, the new rules we just passed, and your commitment to protect public health, safety, welfare, and the environment. It would also set a horrible precedent. If KPK can post $7,800 per well for reclamation without providing adequate information to justify those costs, then all operators in the state of Colorado will rightfully do the same. The requested relief Frederick is seeking is that single well financial assurance of $100,000 per well location and $30,000 per well for plugging be assessed in the KPK option 4 financial assurance plan. In the alternative, Frederick asked for reclamation costs of $86,000 per well and $31,626 for plugging costs be assessed for all 107 wells within Frederick. When the financial assurance rules were passed, the commission was right to be proud. They were truly the strongest rules in the nation. However, they need to be implemented properly. The staff has already allowed some very smaller operators to use demonstrated costs in a way that we believe is in violation of the rules. This application is the commission's first chance to reset expectations with operators, with your staff, and with the public about what information is required if an operator wants to vary from the single well financial assurance cost estimates, and importantly, how the staff will conduct that review. Thank you.
All right, thank you, Mr. Sura. I believe we've now heard the opening statements, and we now proceed to case in chief, and the first presenter will be staff.
Chair Robbins, may DeCono participate in the openings as well?
Oh, yeah, I'm sorry. Yeah, you are recognized. Thank you. Jump the gun there.
Thank you, Chair Robbins. Not a problem. And also permission to share my screen again for the PowerPoint presentation.
Yeah, absolutely. We'll start the time once you say go. And we can see your screen.
Thank you for confirming. I will say go. Again, thank you for the time, and DeCono is excited to be part of this financial assurance hearing. DeCono is next door to Frederick, experiences many of the same issues as Frederick. The KPK wells at issue being discussed by Frederick and DeCono are similar vintage, similar types of wells, similar types of issues associated with the wells. So generally, you're going to hear about similar relief being requested between Frederick and DeCono. I just wanted to sign point that. DeCono is here to discuss 59 issue wells, we call them, located in DeCono. DeCono is a 9 square mile city, has dealt with oil and gas, and has generally benefited from oil and gas, but in recent years has run into many issues involving oil and gas, specifically involving KPK. Going to the relief that DeCono requests, DeCono's always requested 2 areas of relief here, in either or. And understanding the commission's discussion and interpretation of its rules during the procedural issues, DeCono respects it and is going to proceed accordingly. One of the forms of relief, one of the 2, has always been to require for these 59 issue wells, single well financial assurance that is heightened and based in reality, because these are low producing or inactive wells, and many of them have already experienced issues that we expect to see more of in the future. So in the alternative, so that's request for relief number 1, being that approximately $100,000 per well be put up for these 59 wells, single financial well assurance, as opposed to a blanket across the state. DeCono has not investigated every well across the state. DeCono has looked very closely at the wells within its jurisdiction, and it's here to discuss 59 of those 70 or 80 plus wells in DeCono operated by KPK. And the request is that the $100,000 per well not be put up over the course of 10 years for the reasons that were shown. We're concerned that KBK will not be here in 10 years, frankly, to fulfill its obligations to plug and abandon these wells and reclaim the land. The request is that it be put up now for those 59 wells. In the alternative, Tacona proposes that the wells be plugged and abandoned. So it's not an order to plug and abandon. It's an order to put up sufficient financial assurance now for these wells, these high risk at issue wells, or to plug them. And we'll discuss the benefits of plugging and why that may be a preferable route for ECMC, KPK, and Tacona. Jennifer Krieger, the interim city manager for Tacona, will present testimony related to KPK's operations in Tacona, experience of Tacona with KPK, and known issues related to the 59 issue wells. We also have an industry expert, John Oborn Jr., who will present well by well analysis related to production, revenue, expenses, the marketability of these wells, and actual plugging and abandonment and reclamation costs. As I said, the 59 issue wells are low producing or inactive. It's not all KPK's wells in Tacona, it's just some of them, those that we looked very closely at and determined that they're not producing sufficiently. Even in years of high commodity pricing, production didn't go up. They're incapable of producing more. Again, this presentation was prepared before your discussion this morning. So the relief is to either require sufficient bonding for these wells with a deadline for payment in the near future, or plugging of these wells with a deadline set by the end of next year. I won't go through all the statement of basis and purpose quotes that we discussed earlier. I'll remind you what the guiding principles are. Number one being ensuring that the operator is able to provide assurance that it is financially capable of fulfilling every obligation. The other guiding principle, that these wells will not be left to the taxpayers, to the state, to the city of Tacona to deal with in the future. And again, I think it's clear that if KPK were to decide to plug its wells, that it gets a credit for single well financial assurance. For any wells not on its plugging list. Only 7 of the issue wells are on the plugging list. We believe that 59 should be on the plugging list. KPK claims in its materials presented to date that it actually makes money from plugging its wells, that the equipment at each well can be sold as salvage, and KPK can make up to $75,000, which according to KPK is more than it costs to plug and reclaim a site. If that is the case, and if KPK has trouble paying its single well financial assurance at the end of the day, I think the obvious answer is to proceed with plugging some of those wells, making the money that KPK says that it's going to make by plugging the wells, so that it can provide the financial assurance necessary for the rest of its 1,000+ wells in the state. Again, we believe it's a win-win-win. According to KPK's Form 3, its average daily per well production is 0.958 barrels or equivalent. You'll hear that KPK told Tacona it costs $50,000 to plug a well. That's more than the amount that they are demonstrating, but that's what they represented to Tacona. And as stated, their salvage value can be up to $75,000. So KPK, according to KPK, they're making money. No matter what number you're putting to their plugging amount, according to KPK, they're making money when they plug wells. I direct you to the recent Denver District Court order in the case that KPK brought against the ECMC, and some interesting findings based on KPK's testimony in the case, discussing KPK being put into bankruptcy and financial ruin. KPK needs to spend likely $1.2 million on remediation going forward. KPK's business in Colorado will be insolvent within a quarter or less. Again, assuming that Order 863 is maintained, which the ECMC is pursuing. KPK currently has over 100 open spills. I think we all know that spills are expensive to clean up. This is a financial liability of KPK's, and it doesn't even speak to the number of unknown leaks and environmental issues. The court required KPK to pay a $600,000 bond. KPK contends that it has demonstrated it is unable to secure a bond. I think what we learned in KPK's testimony in that Denver District Court case is that KPK is on thin ice financially. And that is where the fear lies, that we are going to be stuck with these liabilities in the future. Again, KPK is seeking an option 4 plan as a high-risk operator. And looking at KPK's Form 3, they've plugged 14 wells in the past 2 years. Looking at the amount of wells KPK has plugged in the past 5 years, I did the math. It's going to take KPK 103 years to plug its 1,000+ wells in the state. Many of these wells are at the end of their viable life, as Tacona will show today. There's no reason to wait to have them plugged or sufficiently bonded. The evidence will show that KPK demands $25,000 or $250,000 per well, if not more, when an operator says, hey, this well's not producing very much. You know, we're trying to do something with this land. KPK makes money by requiring people, landowners, to pay for them to go away, rather than adhering to their responsibility, plugging and abandon no longer productive wells. Many of the issue wells in Tacona are located in or near subdivisions. 22% of these 59 issue wells have experienced spills. In the next 12 to 15 years, that could be 100% of the 59 wells, based on that rate. Over the past 3 years, I'm sorry. That's 22% have experienced spills in the past 3 years. The average age of the issue wells in Tacona is more than 45 years old. I think it's well accepted that this is at the end of a viable life for vertical wells. And you also get here evidence that the issue wells don't generate sufficient profit to cover their liabilities. In 2022, when we had high commodity prices, KPK did not increase production. You'll hear that there's no market for KPK's issue wells. There's not a buyer for them. You'll also hear that Tacona is entirely horizontally developed. That means that every part of Tacona, except for tiny triangle, is held by production. There aren't leases at issue here. McGee, for example, recently plugged 60 vertical wells in Tacona. It's common and prudent for operators to plug these vertical wells, but KPK won't. Going to the single well financial assurance of 39,460 or 640. I'm sorry if I messed that up. If you also consider material costs, as Mr. Sir discussed, for example, well, KPK in the past has stated that it's either 50,000 or 75,000 to plug in abandoned wells. Now it's saying that it's 39,000. There's no information related to topsoil for reclamation. During financial assurance, that was a big issue. Topsoil is expensive. KPK does not store topsoil at its sites. That didn't become required until after these wells were drilled. Flow line removal, that's not discussed. Flow lines are everywhere throughout Tacona and Frederick. KPK has a single facility for multiple wells. There need to be multiple flow lines to each of those wells. Removing the flow lines, reclaiming that land is going to be very expensive. Access roads. KPK uses access roads. Those need to be reclaimed as well. None of this information is included in the 39,000 that's being proposed. Again, there's a reason that the commission set presumptive limits for single well financial assurance. It's based on plentiful information, is well rooted, is well grounded. Tacona supports 100,000, if not more, in single well financial assurance for each of the issue wells in Tacona. Again, there are certain things that KPK had to provide, certain information KPK had to provide in support of demonstrated costs that it did not provide. Thank you for the opportunity to present. That's all from Tacona right now.
Okay. If you want to stop this, yep, thanks. Appreciate that. I should have brought this up at the inception of this case, but I better late than never. I just wanted my fellow commissioners as well as the parties to know that in previous life, I was an attorney that represented local governments, and the city of Tacona was a client of mine. Oh, I want to say like 2014 to 2018. And I just want to set that out. I do not believe that is a conflict of interest. It was a long time ago, and I did not represent the city on any of the matters involved in today's hearing. But I did want to get that out on the record. And if any commissioner has concerns, do raise them now. Otherwise, we will proceed into cases in chief. Okay, I'm not seeing anyone with concerns, so we will continue forward. With that, we would recognize Mr. Boudreau as attorney for staff. And if you could elevate your witnesses, Mr. Boudreau, and we'll go ahead and get them sworn in before you get into your case in chief.
Thank you, Mr. Chair. It looks like Mr. Cuthbertson is already visualized. And Deputy Director Scott Cuthbertson is going to be staff's witness.
Great. And AAG Davenport is visualized for the swearing in.
Thank you, Chair. Mr. Cuthbertson, would you raise your hand, state your name, and say that you swear to tell the truth?
Scott Cuthbertson, I swear to tell the truth.
Thank you.
Thank you. I'm sharing my screen now. Can everyone see that?
Yes, we can.
Okay, thank you. Deputy Director Cuthbertson, can you state your name, please?
Scott Cuthbertson,
And what is your title?
Deputy Director for Operations for the Energy and Carbon Management Commission.
And how long have you been at the Energy and Carbon Management Commission?
About 3.5 years.
And did you review the Form 3 financial assurance plans filed with ECMC?
Yes,
And can you walk us through that process, please?
certainly. And this may take just a minute because it's been a big process. But I do think it's important that this hearing is seen as the first of a number of applications for hearing that the director has submitted to address the review and approval of option 3 or option 4 initial financial assurance plans that propose the use of demonstrated costs as the foundation for single well financial assurance. It is important to understand both the context and specifics of the director's review process. To implement the financial assurance rules that took effect April 30th of 22, the director created Form 3 for operators to use as the foundation of their financial assurance plan. The terms Form 3 and financial assurance plan are interchangeable, and I'll likely use both terms at times, but they mean the same thing. As you recall, every operator qualifies for one of 4 plan options based on the operator's average daily per well production over the 12-month preceding period preceding the date that the Form 3 is initiated. The options progress from the lowest average per well production option 4 plans to the highest per well production option 1 plans. All operators may also pursue a customized option 5 plan instead of the option 1, 2, 3, or 4 plan that they qualify for. A specific option 1 and 2 operators may also pursue an option 6 plan instead of the option 1 or 2 plan. There are 4 categories of financial assurance. Rule 702 addresses the plugging, abandonment, and reclamation of the well and location. Rule 703 covers 6 specific operations where the amount of assurance is established by forms that administer that specific operation. The operations include centralized E&P waste management facilities initiated and administered by Form 28, remediation projects initiated and approved through Form 27, seismic operations established by submission of Form 20, gas gathering, processing, and underground gas storage facilities evaluated by Form 12, produced water transfer systems using Form 44, and commercial disposal facilities, Form 31. Rule 704 is surface owner protection, And Rule 707 outlines the components of a required annual review, as well as a discretionary review to address any pattern of noncompliance or other unique circumstance. Implementation of the rules begins with what the rules call an initial financial assurance plan that addresses only rules 702, 703, and 704. It is important to recognize, as I just mentioned, that Rule 703 assurance is determined by the various administrative form processes associated with the facility or operation pertaining to that category in Rule 703. Likewise, Rule 704 assurance is based on the operator's surface access as documented through the Form 2 permitting process. As a result, the initial Form 3 plan is focused exclusively on the increased assurance requirements for wells contained in Rule 702. The initial plan includes only the Rule 703 and 704 assurance that was already in place when the Form 3 was created. The assessment of need for an additional Rule 703 assurance is an ongoing effort as part of processing the forms associated with each of the specific operations covered by 703. These processes will likely be organized into the Rule 707 overall assessment of the adequacy of each plan as part of the annual review, which cannot begin until there is an approved initial plan. In the process of preparing a plan, an operator can make a number of choices. In the interest of time, I'm going to limit my comments to the choice that has had by far the largest impact on this process, and that is the choice to propose the use of demonstrated costs as the foundation for single well financial assurance. I'm also going to limit my comments to the impact of that choice only as it relates to option 3 and option 4 plans. The rules require operators who qualify for an option 3 or option 4 plan to provide single well financial assurance for every well. The rules define single well financial assurance as an amount to plug and abandon the well that is based on the depth of the well, plus $100,000 to reclaim each location. The rule defines single well financial assurance amounts are $10,000 for wells down to 4,000 feet, $30,000 for wells more than 4,000 down to 8,000 feet, and $40,000 for wells deeper than 8,000 feet. As the term implies, single well financial assurance is a per well amount to plug the well and reclaim the associated location. In order to determine the per well reclamation amount, the $100,000 location reclamation amount is divided by the number of wells on the location. So the rule defines single well financial assurance for a 5,000 foot well that is the only well on the location would be $130,000, $30,000 to plug the well and $100,000 to reclaim the location. Alternatively, the rule defines single well financial assurance for two 5,000 foot wells that are on the same location would be $80,000 for each well, $30,000 for plugging plus $50,000. 100,000 divided by 2 for the location. The rule defined single well financial assurance amounts were set as a conservative average of all locations in the state, regardless of the location size, topography, amount of equipment on site, extent of flow lines, difficulty of revegetation, or any other distinguishing factor. It's readily understood that the cost to reclaim a small, flat, agricultural proximate location is significantly less than the cost to reclaim a larger cut and fill pad with steep slopes in an area of the state where it's difficult to establish revegetation. In recognition of that, the rules also allow operators to use demonstrated costs that are based on the actual or reasonably expected cost to plug, abandon, and reclaim their particular facilities as the foundation for single well financial assurance instead of the rule-defined amounts. Guidelines for what type of information an operator should submit to support their proposed demonstrated costs were found primarily in the statement of basis and purpose. For context, as of last week, the director has approved 145 plans totaling $471 million of assurance. The commission has approved another 4 plans with $134 million for a combined total of 149 plans with $605 million of financial assurance. The director had denied 38 plans as of last week, almost all of which are plans that requested but did not provide adequate support to use demonstrated costs as the foundation for single well financial assurance. There were 48 plans still awaiting director review as of last week, 2/3 of which are operators with 10 or fewer wells. The immensity of the task of implementing the revised financial assurance rules and reviewing initial plans, as exemplified by the number of approved plans and assurance I just referenced, required the director to make reasonable, qualified decisions based on professional evaluation of the information provided by the operator. We did not have the capacity to request additional information for the plans that did not even attempt to include the information for demonstrated costs contemplated by the rules or statement of basis and purpose. Instead, we denied them and filed some 30 applications to bring these matters to your attention, one of which is the matter before you today. We were intentionally consistent, providing the same level of review for each plan. Of the operators qualifying for option 3 and 4 plans proposing the use of demonstrated costs, only a handful of applications provided supporting information with anything other than a very cursory plugging and abandonment analysis and little to no environmental analysis of reclamation costs associated with the cost to remove equipment, flow line removal or abandonment, an analysis of the area of disturbance, the number of wells per location, decompaction, cut and fill slope recontouring, soil type considerations, salt kill analysis, high priority habitat considerations, topsoil, soil amendments and revegetation information, or stormwater and erosion control concerns, all of which were identified in the statement of basis and purpose as information associated with the evaluation of proposed demonstrated costs. Applications requesting the use of demonstrated costs that had clearly not spent much effort to provide a foundation for their proposed costs were denied, as I mentioned earlier. And that constituted the vast majority of those applications. The director approved a few plans that presented a reasonable foundation for demonstrated costs, knowing the plan would be reviewed annually and could be adjusted if needed as more information was generated regarding the ongoing costs to plug, abandon, and reclaim an operator's wells and locations. The rules allow the director to administratively approve or deny plans where the operator proposes demonstrated costs. If the director denies the initial plan, the operator may file an application for a financial assurance hearing to, in effect, appeal the denial. Because of the number of applications being denied and the desire to facilitate getting an initial plan approved, the director opted to file an application for hearing to request the commission approve those plans as submitted, but without demonstrated costs. The operator could also use the hearing to argue for the approval of their proposed demonstrated cost if they so desired. That brings us to today's hearing.
Thank you for that background, Deputy Director Cuthbertson. So earlier you said that there are 4 categories of financial assurance under rules 702, 703, 704, 707. Does this hearing address all 4 categories of financial assurance?
No, the initial financial assurance plan only addresses 702, 703, and 704. But as I mentioned in my background, 703 and 704 amounts are set through different form processes. So in effect, the only rule amount that is affected in the Form 3 process in the initial plan is the Rule 702 assurance associated with plugging, abandoning, and reclaiming wells, because the 703 and 704 were already set at the time that Form 3 was initiated, and the 703 and 704 are subject to ongoing review through other form processes besides the Form 3.
Thank you. I'd like to switch now to talk specifically about KPK's initial Form 3. Did you review KPK's initial Form 3?
Yes,
And in its initial Form 3, did KPK propose to use demonstrated cost for single well financial assurance?
yes,
Are operators required to provide information to support their demonstrated cost as part of their application?
yes.
And in KPK's initial Form 3, did KPK submit information to support their costs?
KPK submitted information that they asserted supported their costs, but the director's review found the information to be not sufficient, a not sufficient foundation for their proposed demonstrated costs.
And what decision did you arrive at after reviewing KPK's initial Form 3?
As I mentioned, it fell in the category of applications that had not presented what we considered to be even a reasonable effort at providing the support documentation provided. So the plan was denied.
Okay, the plan was denied. And how did you arrive at that decision?
Well, like I said, the initial Form 3 submitted in this case included almost no foundation for the proposed demonstrated costs. And also the proposed costs of $8,100 to plug and abandon a well and $1,500 to reclaim a location were significantly lower than, in my assessment, could even be supported. As a result, the proposed 702 assurance in the initial plan of $10.3 million as opposed to the rule-defined single well financial assurance of $133 million was denied.
Okay, so these numbers on the screen here, this was the numbers KPK proposed in their initial Form 3, is that right?
These are the numbers that were proposed in the Form 3 that is the subject of the hearing today.
Thank you. So next, the director filed the notice and application of hearing, which led to this hearing, right?
Yes.
And what kind of relief did the director initially request?
Initially, all of those applications requested that the commission implement the submitted Form 3, the Form 3 as submitted, except without the proposed demonstrated cost. In other words, to go ahead and approve the Form 3 using the rule-defined single well financial assurance amounts.
I see. But since that time, staff's position has changed, hasn't it?
Yes.
Why did staff's position change?
On July 21st, the operator submitted information regarding demonstrated costs totaling approximately $43 million. The director found the information provided a reasonable foundation and indicated that in our response to that submission. While it is moot at this point, I would just note that had the operator provided the July 21st information as part of their original Form 3 submission, the director would have approved that plan.
I see. So what is staff requesting now?
Staff is requesting an order as that KPK initiate a new Form 3 in order to correctly account for wells that have been plugged since the submission of the previous Form 3 that uses demonstrated costs that are based on the July 21st information.
Thank you. And based on your review of KPK's July 21st filings, what financial assurance amount is the director recommending the commission approve for KPK's demonstrated costs?
So the director is asking for the commission to approve the use of demonstrated costs for this initial financial assurance plan in the amounts of $31,626 for each well and $8,600 for each location. I should just note that in order for the Form 3 to correctly calculate a per well reclamation cost, the demonstrated average per well reclamation cost of $78.34 provided by the operator must be converted to a per location cost. As can be calculated from the attachment B table and staff exhibit, the demonstrated costs accepted by the director had 1,086 subject wells on 989 locations. So to use these numbers in a new Form 3, which is required to correctly account for wells that have been plugged since the submission of the previous Form 3, the per well reclamation cost must be converted to a per location cost. To get the per location cost required by the Form 3, the average per well cost, the multiplicand of the average per well cost must be multiplied by the number of wells and divided by the number of locations. So 7834 times 1,086 divided by 989 is $8,600.
Thank you for clearing that up. And assuming the commission issues the order requested by staff, which is for director approved demonstrated cost, what is the process to accomplish a final financial assurance plan for KPK?
So we will need a new Form 3. The Form 3 that was submitted is denied. There is no way to administratively undo that denial. We also need a new Form 3, as I mentioned, so that the correct amount of financial assurance can be calculated for the wells that are remaining that have not been plugged. There's a few wells that have been plugged, but regardless, we need a new Form 3 that uses per well cost or uses a foundation for single well financial assurance that is the subject of the commission's review today.
Okay, so the new Form 3 would include the approved demonstrated cost and then on a single well financial assurance basis, and then you would multiply that by the number of wells that KPK has subject to Rule 702 at the time they file the subsequent Form 3. Is that right?
That's what the Form 3 does. The Form 3 does the complex math of tracking the wells and how many wells are in each location using the per location amount of reclamation, not the per well amount of reclamation.
Thank you. And if the commission were to enter the order today, which staff is requesting, would KPK be required to post the entire amount of financial assurance this year?
No, not in accordance with the rules under option 4. The operator only is required to annually submit 10% of the total assurance provided, beginning within 90 days from plan approval and then continuing annually thereafter by July 1st until such time as the entire approved assurance has been contributed.
Thank you. Did you have anything else you wanted to add today before we wrap it up, Deputy Director?
Thank you. I do want to acknowledge the frustration expressed by public comment this morning. I also want to acknowledge that staff and the commissioners are also frustrated with the effort that the commission has had to expend to administer this operator. But I also want to acknowledge what I believe are robust rules regarding financial assurance and the importance of applying them well. The rules implemented by this commission authorize the director to assess the reasonableness of demonstrated costs. It's important for the commission to acknowledge that analysis absent evidence to the contrary. It's also important to appreciate that there are a number of processes to determine the total financial assurance required for an operator to comply with the rules. The hearing today is the first step, approval of an initial plan. There was significant concern expressed about the number and status of remediation projects associated with this operator. As I mentioned earlier, remediation-based financial assurance is a Rule 703 category of assurance that is determined through the Form 27 process. The director is evaluating the need for additional financial assurance required to address stalled remediation projects for this operator. But as I just stated, that is not part of the initial plan approval process. It's part of the Form 27 process. Should additional remediation assurance be authorized by the director as a result of a Form 27 approval, that authorization will also require the submission of an updated Form 3 in order to obtain the additional assurance. There was also concern regarding the adequacy of the financial assurance amount accepted by the director. Pursuant to Rule 707, the director will be reviewing all plans annually and specifically monitoring plans using demonstrated costs. Any need to modify those costs will require the submission of a new Form 3 with direction as to changes necessary to adjust those costs. This is a new process, and it's the first hearing in that new process. If the commission is concerned about or simply lacks confidence in the director's ability to provide a reasonable review of demonstrated costs, the commission can provide the aspects of those concerns that it would like for the director to include in the first annual review of the plan, a review that could begin as soon as an initial financial assurance plan is approved. Similarly, there was significant support for additional financial assurance because of the operator's overall compliance status. But that is also not part of this step in the process. It's part of the Rule 707 discretionary review, which requires a specific hearing before the commission that cannot happen until we have an approved initial financial assurance plan. So I very much appreciate that the administrative process can be frustrating at times, but 23 years as an administrative agent for the state of Colorado have taught me the importance of following a consistent, careful implementation of rules so that everyone has confidence in our administration of not just this issue, but of all the commission rules. Thank you.
Thank you, Deputy Director Cuthbertson. Mr. Chair, I don't have any other questions for Mr. Cuthbertson at this time, but staff would like to reserve the rest of our time for any necessary rebuttal. And I believe we also discussed the need to specifically offer exhibits into evidence at the end of a party's case in chief. And so staff would like to do that now, with the exception of staff's exhibit. Yes.
Hold on just a sec. I think what is next, and AG Davenport, correct me if I'm wrong, but I think that each of the other lawyers gets a chance for cross-examination, and then you get a chance for redirect if that's necessary. And there's also the opportunity for commissioner questions and some redirect on your part as well after that. So maybe it makes sense for us to hold on the exhibits until after we've gone through those other things, because I think at the end of that, you'll be ready to rest your case in chief. Does that sound fair, Mr. Boudreau and AG Davenport? Did I get the order of play right?
Chair, I don't have any, yeah, your order of play is correct to me.
Yes, that sounds fair to me, Chairman Robbins. Sorry, I just wanted to make sure we got the exhibits handled.
Yeah, no problem. Okay. So with that being the case, I would recognize Mr. Jacobs if he has any cross-examination for the witness.
No, but I do wish to thank him for his 23 years of service as an administrator of the commission, and no questions on cross. Thank you.
Thank you very much. Agreed on the appreciation. Then I would ask Mr. Sura if he has any questions on cross-examination for the witness.
Yes, thank you, Chair. And my appreciation as well for your 23 years of service in the state. Deputy Director Cuthbertson, you had mentioned that there was a review that is done by staff of these applications generally, and specifically when there is demonstrated cost requested. Is that undertaken by you, or are there other staff that are involved in that?
Early on in the process, I did consult with a number of our staff subject matter experts to develop both a review template and some contextual standardization of the review so that we could represent that we had given a consistent review to each application. So early on, I did consult with a number of our subject matter experts to establish the template that ended up being used, and some early plan reviews to just work out the sort of calibrate the review. After that, I did the bulk of the review, only asking for input if I felt like that there was a circumstance that an operator presented that we had not contemplated in the development of our template.
Thank you so much for that. And there are reclamation experts within the staff of the ECMC, is that correct?
Yes,
And did any of those experts, and which of those experts were involved in the review of this application?
none.
Okay, thank you.
Okay, we then recognize Mr. Louis Prescott, if he desires any cross-examination.
Briefly, thank you, Chair. Deputy Director, a couple questions. With this supplemental Form 3 that was submitted last month, did staff request any additional information from KPK?
Don't believe we did. If you're referring to the July 21st supplemental information, I don't recall requesting any additional information in my review of that. No.
Okay. Was any information provided related to the cost of topsoil for reclamation?
I don't recall off the top of my head the details of what was provided. I'm sorry, I would have to look at the information again.
Do you recall if any information was provided related to the cost of removing flow lines and reclaiming that land?
I'm sorry, I don't recall off the top of my head.
And as I understand, there are kind of 18 example wells that were provided by KPK. Is that an accurate description?
Yes.
And did staff undertake any investigation as to how those 18 wells compare to the other 1,000+ wells operated by KPK in the state?
No.
You know how many wells KPK has plugged in the past year?
A few.
Thank you, Deputy Director, for your answers and your service.
Okay, all right, I'm flying by the seat of my pants here. I think the next appropriate step would be commissioner questions. And that way, Mr. Boudreau, when you get to redirect, you kind of are redirecting on all the questions. Does that sound fair?
Yes, Mr. Chair. Thank you.
Okay, then that's kind of how we'll do it for each witness as we build the template of how we're going to process this. Okay, so commissioners, you now have an opportunity for questions for the witness, or we. Oh, my hands are flying. Mr. Cross beat Commissioner McGowan by a hair.
Thank you, Mr. Chair, and thank you, Deputy Director Cuthbertson. If we could, one of the last things you talked about going into some of the frustrations expressed from public comment, as well as within staff and everything else, you talked about the order in which things are going to be reviewed between the initial financial assurance and the revised financial assurance. And I'd like to go back and touch on that a little bit because you said certain things are covered in 702, but other things are covered in 703 and 704. So briefly, could you go back and provide a little bit more detail on that?
Certainly. So Rule 702 contained the bulk of the changes from the revised 700 plans. Rule 703 codified existing processes that included assurance for those specific processes, as did 704. I don't think it was I don't think either one of them were necessarily new, but they did update how the administrative process to calculate the amount of assurance required for those 6 specific operations and the surface owner protection bond. And so those amounts of financial assurance were set. Those amounts did not change because of the implementation of a Form 3. Primarily what changed with the implementation of the revised rules was the amount of plugging assurance associated with wells. And so the initial Form 3 for every operator, when they filed that Form 3, the Form 3 simply looked at our database to see what 703 and 704 assurance had already been approved through those other administrative processes, and it incorporated those amounts into the plan because that was what the rules required, that initial plan to include 702, 703, and 704. But the initial plan did not evaluate anew any need for additional 703 assurance or 704. The impact of the implementation of the Form 3 for this initial plan really is just the 702 well-based plugging assurance.
And I appreciate that. And I guess one of the things that I want to try and understand, because I think what we heard in openings, what we heard in public comment, and even what you're seeing in some of the numbers, where a bunch of the discrepancy we're seeing is in that remediation cost, the $100,000 example, $100,000 per well versus the 30,000, because the demonstrated costs are about $30,000. And so I guess what I'm trying to understand then is where does that $100,000 get evaluated? Is that evaluated as part of the initial financial assurance review?
Yes, so Rule 702 is for plugging, abandonment, and reclamation. That's what Rule 702 addresses. And so for option 3 and 4 plans, the rules specifically require single well financial assurance, which is just a term. It requires that kind of financial assurance for every well. And that kind of assurance is defined as either the rule defined amounts based on the plugging depth and $100,000 for each location, or the foundation provided by an operator that the director finds reasonable in terms of demonstrated costs. Those demonstrated costs are also single well financial assurance if found to be reasonable. And so, did that answer your question?
I think so. And what I'm hoping to get at a little bit there is especially what you touched at the very end, is that review. And part of what I want to understand is you talked about the Form 27 and looking at additional financial assurance or that may be required based on additional remediation, outstanding wells, outstanding spills, issues like that. And so I'm curious as to where the demonstrated costs are looked at specifically with respect to the reclamation, as opposed to the Form 27 that you're talking about that you said will then be looked at later.
Yeah, so
because to a certain extent, I'm seeing a little bit about the plug-in and abandonment costs, but there's that larger discrepancy when it comes to the reclamation aspect.
Yeah, so it is important to distinguish between those two things because they are two different things. Reclamation is simply the cost to return the land to its pre-production condition once the well is plugged and abandoned. It presumes no extensive, at least, remediation being required, right? Most pads can be reclaimed, especially small, flat, agriculturally proximate pads can be reclaimed with some deep tilling and some surface amendments, some surface work, not unlike what a farmer does many years in their fields, and some time to allow that land to be revegetated. That's reclamation. Remediation is, the remediation-based assurance in 703 is an operator has a pipeline spill and it's got groundwater impacted, and there's a multiple year need for operational support for that remediation project. And the director believes that it's appropriate, given the long-term or the stalled nature of the remediation that's going on, to above and beyond the plugging, abandonment, and reclamation assurance, to above and beyond that to request additional remediation-based assurance to address that one project. That's why it's part of the Form 27. And, you know, I appreciate that. I wish that we had the capacity to go faster. The implementation of these rules has been significant. Part of the reason that I was delegated the responsibility for doing this was both because of my particular expertise in the matter, but also because we did not have any staff allocated to do this work. It has been a significant amount of time required to review these plans and to provide a consistent approach to it. We are in the process of hiring 2 new positions. We're in the process of recruiting those. So we will be able to go faster, but we have started the 703 review of remediation projects for all operators, not just this operator. As part of one of the things that our environmental unit has begun. When we think about, okay, now how do we effectively organize that effort? Our thoughts are that will be funneled into the Form 3 through the annual review that we expect to begin this fall. And so, you know, in the very near future, you will begin to see the director authorizing, I think, some additional 703 assurance for a number of different operators that will then prompt revised Form 3s, which the rules contemplated as part of the annual review process. And so the part of my frustration, and I felt it felt it viscerally this morning as our stakeholders were expressing their frustrations, is that there are a number of steps to get to the total financial assurance condition that we need to get to. I wish that we could have done all those steps in parallel, but we simply don't have the staff to do that. We had to break this up. We had to eat this elephant in chunks that we could chew. And so, but I am very pleased with the work that we did. You know, just at the risk of leaving people out, we hired a senior permitting manager who had retired, and we brought them back for an entire year to help us implement the rules. It was a significant amount of effort that was applied to doing that. On her departure, I stepped in and finished the implementation process. And so I believe we're in a good place in terms of implementing the rules. I believe we've done them fairly and consistently. And so that's the response I would give, is that you do have to keep those 2 things separate. Reclamation, think of reclamation as the amount of assurance to simply close out a clean, unimpacted pad. Mostly clean, unimpacted pad. Think about remediation as, oh my gosh, there's a significant remediation project here that will last for some period of time that the director believes we need some assurance for to make sure that it's completed by the operator.
And I think that was the key part of what I wanted to hit. And so I think, to summarize for everyone's edification, including the public listening, what we're looking at here is just 702, which is looking at the plugging and abandonment costs and looking at the reclamation costs, not the 703 remediation, which is where everybody talked about the spills, about the constant, everything that was covered under the CPA, which was a part of another hearing. We're talking about just the reclamation. So staff's position is that the $31,000 and change per well is adequate as a demonstrated cost for the plugging and abandoning, and that the $8,600 for location is appropriate for reclamation only of the type of wells that we see with KPK, but remediation may happen down the road with additional financial assurance in connection with the Form 27s.
Correct.
Commissioner Cross, if I could, this is going to be a long hearing. I'd like to move around and let some other folks ask questions, then we can come back. That way we're all getting an opportunity, because I know everybody's got their hands up. Are you, I don't want to cut you off, but I think you summarized that first questioning point.
And that's exactly what I was going to say, is that's what I wanted to make sure that we had summarized from the testimony.
Okay. Commissioner Messer, I know you just raised your hand. Commissioner McGowan had raised her hand earlier. I'll recognize Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Mr. Cuthbertson. Deputy Director Cuthbertson. I think this has been really confusing, not just for the public, but for the commissioners. And I think how we contemplated the financial assurance during rulemaking, right, was kind of holistically, not as we'll do this piece, then this piece, then this piece. And I think that's why you hear consternation from folks. But I think I'd like to ask a couple to build on what Commissioner Cross is trying to clarify. So when you were looking at the demonstrated costs, did staff say, so I'm trying to bifurcate what we would require, not in 702, but 703, and figure out what it is that we would look at as part of 702. It seems common sense to me that we would ask KPK for the actual invoices from the last 3 years of all the wells that they've actually P&A'd and reclaimed. Did staff look at that information or ask for that information?
No.
So those would be real numbers, right? That actual costs of projects that they completed in the last 3 years. And it is in our guidance as part of statement of basis and purpose. And I think that's not just limited to 703, but could or should be applied to 702?
Yes, if I could expand perhaps my response beyond just your straightforward question. There is, I think, some, so what are demonstrated costs is a question that we have been asked. Demonstrated costs, actual receipts and invoices of actual plugging, abandonment, and reclamation operators over the last 3 years are definitely demonstrated costs, right? Those are what the director would contemplate as being demonstrated costs. Is it only the activities that the operator itself has conducted, or is it activities that the operator is aware of, say, conducted by the Orphan Well Program, where they may have been a bidder on that work? And I'm not talking about KPK at this moment. I'm talking about a different operator. As the director reviewed the reasonableness of considering the foundation of those demonstrated costs, we could not see a reason to not accept the presentation of the costs associated with similarly situated wells, with wells that were similarly situated to the operator at issue as their foundation as well for demonstrated costs.
So the 18 exemplar wells, are they KPK's wells, or are they wells that they're pointing to that say these are like our wells?
No, the 18 wells involved in the July 21st supplemental are KPK wells.
And so how do you know that what KPK chose are representative of more than 1,000 wells, for example, that they have? How did you all decide that that was the right 18 exemplar wells, and didn't ask for the last 3 years, for example, of actual invoiced costs to P&A their wells? Those would be recent costs. They would be. So sorry, I'm trying not to be critical while I ask, but trying to understand kind of the thought process for you and staff as you went through and said, these 18 wells are a good representative of the population, I guess, when also, and I know that they plugged this many wells last year and this many the year before and the year before. And guidance and statement and basis of purpose says I should be looking at the actual invoices and costs of what they themselves have plugged in the last 3 years.
So the exemplar wells that were presented in the July 21st presentation had not been abandoned, right? They were simply example wells and what I found to be a reasonable engineering estimate of what it would be to plug and abandon that well. The appropriateness or the essence of that well being a representative of the category of wells was a contextual understanding of the operator's assets. It wasn't a detailed analysis of, oh, this is the exact same, right? Many of these wells of the vintage, as you heard the cities testify to earlier or in their opening statement, the vintage of these wells are all really similar. The construct is all really similar. They're in similar formations. There is a lot of similarity to the wells in this operator's portfolio. And so for an initial plan, the director found that the cost analysis that the operator did was within reason. Was it perfect? No. Nothing's ever perfect, but it was reasonable. And I need to backtrack just a minute because I need to go back to what is demonstrated cost, because one of the things that the director contemplated as evidence of demonstrated costs was not actual plugging and abandonment, but was what some would call design information for what it would cost to plug an abandonment that's based on similarly situated or contextual experience regarding this. That was a foundation that was part of the director's demonstrated cost analysis, because in our absent guidance that we could not find the specific guidance that limited it to actual to the actual costs incurred, even though that clearly is the gold standard for demonstrated costs. We found it reasonable to accept an unrealized but anticipated cost foundation and determined whether or not that unrealized cost was reasonable as a foundation for demonstrated costs.
Okay. So sorry, one last question, then I'll let other commissioners ask as well. Of the 18 exemplar projects, were any of them projects that had open remediation attached to them? So I get that you're saying, oh, we're going to deal with the remediation within 703, but if we're going to take like a bell curve of projects from this operator, we know that there are a substantial number with open remediation projects that would affect the bell curve and the demonstrated costs, because remediation by default is part of reclamation. You can't get to reclamation until you've completed remediation also. So it's very hard for me to try to fit in how you can just completely separate any remediation from consideration of demonstrated costs for the 702. So I'm really trying to wrap my brain around how that works, how that can work or should work.
And so I appreciate it's really unfortunate that because of the amount of staff that we have to address this and the timing that we were trying to get it done in, that we felt like we had to compartmentalize this process. There is some guidance in the rule that talked about an initial plan getting approved. There's no direction in that to exhaustively examine remediation. That's in 703, not 702. And so we felt like that we were implementing the rules appropriately, and providing a fair and consistent analysis of every operator's initial financial assurance plan by relegating the remediation issues to the Rule 703 Form 27 process, which
Okay.
we are undertaking. We're not doing that. You're just not hearing about that today. It's not part of this hearing. This hearing is about really just Rule 702 and the initial assurance plan.
Okay, so sorry, just to clarify, do you remember if any of the exemplar projects are any of those projects that have open remediation attached to them?
Again, Commissioner, I'm sorry to frustrate you, but we compartmentalized it. We did not look at remediation, the large issues of remediation for any operator as part of their Rule 702 initial financial assurance plan. No operator. We just felt like that the most effective way to address that particular issue of financial assurance was with our environmental unit through the Form 27 process, not the review of the initial Form 3 process, so that we could get the initial Form 3s approved as timely as possible and begin to collect some of the $600 million in financial assurance that has been offered.
I'll let someone else go. Thank you.
Commissioner Messner.
Thank you, Mr. Chair. Deputy Director Cuthbertson, thank you for being here. I got a number of questions that I need to ask. But first, am I echoing again?
A little bit.
I'll start it. 1 second. How about now? Am I still echoing?
That's better. You're good to go.
Okay. So do you acknowledge that this commission's tasked with reviewing the full financial assurance plans associated with particular operators as part of our process, and primarily determining whether the operator has the financial capabilities to meet all of the financial obligations associated with the act?
Yes.
Thanks. And I'm trying to find in the rules where it is determined that, in these commission hearings regarding financial assurance, that we're just reviewing Rule 702. I clearly read in the rules that we're reviewing 702, 703, 704, and any other relevant information that we need to be able to review in order to determine whether or not the operator has the financial capabilities to meet all of their obligations under the act. Unless I'm missing something.
I don't believe you are, Commissioner Messner. I'm simply explaining to you how we have implemented the financial assurance plans required by rules, that because of the immensity of the effort, we had to take a stepwise approach that limited the review. If I had done an exhaustive review of every operator's location conditions, I would not have been able to approve 145 plans as of last week. It would have extended out the approval of that initial plan review that we felt like was less effective than separating out different aspects of the financial assurance rules and dividing and conquering, if you will, where the Form 3 review was focused on the Rule 702 adequacy. Our environmental unit began work on 703 issues. Primarily remediation is the only 703 issue that's at significant impact. To try to integrate the two of those into an initial plan review as we contemplated it early on made us forecast the approval of the initial plan process to take significantly longer than we wanted to take. Our objective was to try to get initial plans approved by the time the federal well exemption expired.
But that's Deputy Director Cuthbertson, that's different than what the rules anticipated and the statement of basis and purpose anticipated. And I'm struggling to see the discretion allowed by the director to not apply the rules as promulgated by this commission.
So Commissioner Metzger, we are implementing the rules. The 703 rule directs us to initiate remediation-based assurance through the Form 27 process. That's what your rules say. And that's what we are doing. You simply haven't seen any of those yet, but that is how we are implementing remediation-based assurance, is through the rule prescribed Form 27 process under 703.
But in order to be able to approve or make a recommendation on a financial assurance plan, which encompasses 702, 703, 704, all those processes need to have been completed before a determination can be made.
I guess I respectfully disagree that, especially with the construct of option 3 and option 4 plans, where the operators are provided 10 or 20 years to provide their financial assurance, approving of an initial financial assurance plan that at least begins the contribution of that amount in the most timely way possible is arguably more important than getting an exhaustive plan researched and approved 2 years later.
So again, I mean, we'll move on here in questions, but I respectively disagree with you and don't believe that the director has that discretion within the rules. But I do want to ask about submittal requirements associated with financial assurance plans and the clarity associated with the statement of basis and purpose around those submittal requirements, and just make sure that I understand, because I thought I heard you say in response to Commissioner McGowan's questions that in your words, the initial financial assurance plan submittals may require less information to be provided by the operator than a subsequent or an annual review.
No, I don't believe I said that. What I said was that the analysis provided in the initial financial assurance plan review was a qualitative contextual analysis based on our operational understanding of each operator's facilities and operations, that did not include any detailed engineering analysis, any detailed design review, that it relied upon our qualitative experience as to what we had seen as being reasonable costs for those operators' wells as situated for each operator, and in response to a cogent presentation of proposed demonstrated costs by the operator. We had many applications that just made the statement, it costs us X to plug and abandon a well without any foundation. And we denied those plans, just like we denied this plan initially. That is not what I found the July 21st submission to be. And to provide the same level of review consistently with the other plans that were reviewed, we did find that the information in the July 21st submission was not perfect, but was reasonable, especially recognizing that we have the ability to review these plans every year in order to get an initial plan approved.
So, but at a minimum, as indicated in the statement of basis and purpose, submittal requirements should include known remediation issues, areas of initial and total disturbance for the oil and gas location and associated offsite facilities, number of wells at the oil and gas location, whether the oil and gas location has cut and fill slopes, and if so, the slope ratio of both the cut and slope and the fill slope, whether the oil and gas locations have sandy soil, whether there's any salt kills, whether it's in high priority habitat, whether topsoil has been salvaged. And I think what I heard you say earlier is that some of those were not provided by the operator, specifically around topsoil, around cut and slope, sandy soils, around even retirement plans associated with their oil and gas operations, which is not even in that list, but in the list within the rules, not within the statement of basis and purpose. And so I'm struggling to understand, without this necessary information, even if we take your presumption that we're only reviewing 702 today, which includes reclamation. I mean, reclamation includes associated facilities. Reclamation includes cut slopes and sandy slopes. Reclamation includes water management. Reclamation includes topsoil, which is very important. I mean, how are you making that determination on reclamation costs without that level of detail or that information that is necessary to provide?
So like I said, it's made qualitatively and somewhat contextually. The operators' locations are primarily, in fact, exclusively east slope for this plan as it's approved or as it's submitted today. Their federal wells are still exempt from the financial assurance rules. So the locations are all flat, relatively small, all pretty agriculturally proximate. Topsoil, stockpiling topsoil is not a significant issue for those kinds of locations. Stockpiling topsoil is a more relevant issue for remote cut and fill slope type installations where it's going to be difficult to get topsoil to the site. And there's not much topsoil, there's not any topsoil to be harvested on the site, but for eastern slope, small agriculturally located locations, topsoil is not a significant factor. That's a contextual, qualitative analysis that was included in part of the reasonableness evaluation, and that applies to the other issues. Like I said, not every location needs remediation. These were exemplar locations that were used to represent an average of that category of wells, and I accepted that information as being reasonable.
I don't have any further questions, Mr. Chair. Thank you.
Commissioner Ackerman.
Thank you, Mr. Chair, and thank you, Deputy Director Cuthbertson, for sitting on the hot seat and for also the work associated with this. I recognize and understand the massive scope of work that your position entails, and appreciate you being here with us today. I have just a few questions, the first two of which should, I think, be pretty brief. The first one would be, does staff know what KPK has paid to plug and abandon and reclaim any well that it has plugged in the past few years? And if not, that's certainly a question that I'll have on my docket to KPK.
I do know that we know that information. I don't know it off the top of my head, but we do have information with this operator where they have submitted plugging and abandonment costs as part of other administrative decisions that have been involved. I just don't remember what they are.
Thanks so much, Deputy Director. And I think that information would be helpful to me if there's any way that we could get that sent to us as part of these proceedings. Do we have any more information on reclamation costs that is standard? For example, do we have any data on standard statewide averages or standard averages by basin or well type, or the standard average, for example, to reclaim ag land sites, other than just kind of anecdotally what we see come across the desk?
I'm confident our reclamation team has that kind of information that they could assemble. I don't have it in front of me.
Thanks again, Deputy Director. Again, I think that information would be helpful to me as a commissioner if it's compilable on short order. And then I guess my main question or musing is this, and I think you've partially answered this, but I want to kind of give one more opportunity to put you on the hot seat here. You know, at face value, staff's recommending a per well reclamation cost, and I'm staying away from the P&A cost for the purposes of this discussion. But a per well reclamation cost that is 7% of the standard cost established in rule. And so to the average onlooker, that would constitute a significant deviation that may not seem reasonable, which is the word we keep using. So that would lead one to believe that either the standard cost to reclaim a well is set, you know, at an exorbitantly high rate, or that KPK wells are, you know, vastly different from all other wells. So could you address that direct point? Why staff found that such a large deviation from the standard reclamation cost would be reasonable for the purposes of this hearing?
So I do think you have to remember what the $100,000 represented, and that was an average statewide cost. One of the local relevant governments, I don't remember whether it was Tacona or Frederick, did provide a submission of a PowerPoint presentation that the director used early on in the rulemaking process to solicit information regarding the cost to plug, abandon, and reclaim facilities statewide. And that's their $32,000 cost or something as the typical site. I can't remember off the top of my head, something like that. But in that same presentation, you know, reclamation experts for the commission at that point in time acknowledged that there were some sites that could be reclaimed from anywhere from $0 to $28,000. Some sites required $300,000 or $400,000. When you talk about trying to reclaim a cut and fill slope site in a remote location in Western Colorado, it's a significant cost to try to undo the cut and fill slope. It could be $300,000 or $400,000 to reclaim that kind of a location. And so, because the rules, in my understanding of the deliberation, were attempting to reach some conservative but applicable definition of what single financial assurance was, the $100,000 was picked as a median kind of number. Those operators with cut and fill slopes that have to provide single well financial assurance are happy to sign up for rule-defined single well financial assurance because their demonstrated costs may be 3 or 4 times the $100,000. But dissimilarly, operators with, like I said, small, flat, relatively aggrable, you know, properties, you can't pass the red face test, almost, in my assessment, to say, you know, a 1/4 acre property in Weld County is going to cost you $100,000 to reclaim. So that's the contextual analysis that went into this. And that's how the $100,000 I see as being the result of the rule defined, and why the commission even contemplated allowing demonstrated costs as the foundation for single well financial assurance instead of simply leaving it with the rule defined amount.
Thank you, Deputy Director. I appreciate that additional explanation. I do, as the Reclamation Commissioner, have some experience with reclamation and can attest that that costs can deviate significantly based on site conditions. Again, though, it does still seem like a significant reduction on average. And so my final question would be, and again, this is another put you on the spot question, and it may not be available at the top of your head again, but do you know if we've approved any other financial assurance plans that on the reclamation figure have deviated at or near this amount from the standard reclamation costs?
Yes.
Yes, we have.
Yes.
Okay. Thank you for answering my questions, Mr. Chair. I'll leave it at that for now. Oh, you're muted, Mr. Chair.
Thanks. And having let my other commissioners ask questions, I don't believe I have any questions at this point. Commissioner Cross.
Thank you, Mr. Chair. I just have one follow-up. So you did talk a little bit, Deputy Director Cuthbertson, about the Form 27. And just to make sure we're all on the same page, any approval of the Form 27 will come after the initial financial assurance is approved. Is that correct?
At this point in time, yes, sir, just because we didn't get any Form 27s approved before the operator had submitted their financial assurance. Their
And is
initial
there-
financial assurance plan.
Is there a Form 27 pending for KPK currently?
There are a number, yes.
That's all. Thank you. You're muted again.
At this point, Mr. Boudreau, having accomplished Cross and Commissioner questions, you have an opportunity for redirect.
Thank you, Mr. Chair. Deputy Director Cuthbertson, thank you for your clarifying answers there. I don't have anything specific for you on redirect, but is there anything you'd like to clarify before we wrap up staff's presentation?
I don't believe so. Thank you.
Thank you, Deputy Director.
Okay, good. We've been going at it a couple of hours. I think we're going to go till 5 today. Let's take 5 minutes, and the next presentation is going to be KPK's presentation. And during the 5 minutes, KPK can get their witnesses up on the panel.
Mr. Chair,
Yes.
before we take a break, I believe we are now.
Oh.
I tried to jump the line earlier. And
Yeah, you're right.
I
We
think
gotta
it's my
do the
turn now.
exhibits.
Thank you. So staff would like to offer staff exhibits 1 through 5 into the record. And as to staff exhibit 6, I believe that's the only one for which we received an objection. And that one had to do with salvage value, which is no longer an issue here. So staff is willing to drop staff exhibit 6, but we would still like to move for staff exhibits 1 through 5 to be put into the record. And it's our understanding that for those 5 exhibits, we received no objections.
Is that accurate? Does anybody have an objection to 1 through 5?
No objection here, Mr. Chairman.
No objection from Dacono. Thank you.
No objection. Thanks.
All right, exhibits 1 through 5 are admitted. All
Thank
right,
you.
let's take our 5 now. It is 4:04. Let's return at 4:09. All right, welcome back. This is the ECMC August 16th meeting. We are continuing in docket 2304-00117. At this time, the next presentation is by KPK, AAG Davenport. If you'd like to swear in the witnesses, and if all of KPK's witnesses would visualize themselves, we'll get through that process.
Mr. Chair, Mr. Kaufman can turn on his camera, and then I believe a second witness for our direct testimony and case in chief is coming down to the witness room. So if you'll just wait a second, here she is. If you could both sort of kneel down. That'll work. We have a fixed monitor there with an integrated camera.
All right, thank you. For both witnesses, if you could just in turn raise your hand, state your name, and that you swear to tell the truth, please.
I'm Jeffrey Kaufman, swear to tell the truth.
I, Lily Clark, swear to tell the truth.
Thank you.
Good. We'll call our first witness, Jeffrey Kaufman. Mr. Kaufman, thanks for being here this afternoon. Please state your full name and current employment position for the record.
Jeffrey Kaufman, and I'm the President and Chief Operating Officer at KPK Kaufman Company.
When did you join KPK full-time?
Joined KPK full-time in 2010.
And can you please summarize your post-secondary education for us before joining KPK full-time?
I earned a Bachelor's of Science degree in electrical engineering and a Master's in electrical engineering from Cornell and a Master's in business administration from Cornell.
Thank you. And what employment experience do you have following graduate school prior to joining KPK?
Worked as a financial analyst for Merrill Lynch in 2008 prior to joining KPK in 2010.
Very good. Turning to the issues raised for this hearing, Did you assist in the preparation of KPK's initial Form 3 financial assurance plan and related documents submitted to the ECMC on November 1st of 2022?
Yeah.
And were actual invoices of costs for plugging and abandonment and reclamation provided with that initial financial assurance plan?
Yes, they were, and it was denied.
And that plan was submitted under option 4 of the financial assurance rules. Is that your understanding?
Yes, that is correct.
Why is that? Can you explain why that's an option 4 submission?
I believe it was dictated by the number of wells and their average production.
And what is KPK's average production across its wells noted in the Form 3? Do you recall?
It's just under 1 barrel a day now.
Mr. Kaufman, what factors affect that average rate of production from KPK wells in your experience?
Several factors do, including wells that have been temporarily shut in, well maintenance such as workovers, lack of refracs in recent years that have historically increased production significantly. And the director's 911A order to shut in numerous wells has affected our average per well production rate.
Thank you. Mr. Kaufman, do KPK wells have significant remaining reserves capable of production?
Yes, they do. Some of that information was set forth in the attachments to our Form 3 submitted under confidential business information.
Is that information you're referring to in a document that we'll screen share and show? My colleague, Mr. Killian, is screen sharing. Do you see the screen that he's screen sharing, Mr. Kaufman?
Yes.
And is that the cover sheet of the document you're referring to that was submitted with the original Form 3?
Yes, it is. And
You're indicating does set forth some reserve information.
it does contain reserve information about the spindle field.
And although subject to confidential business information claims, that information should be available to the commissioner, should it not?
It should be.
Thank you. What is the approximate remaining primary production to be recovered from KPK spindle field wells as indicated in that document, if you recall?
It is quite significant. I believe it's about 7 million barrels of oil and 41 BCF of gas.
Would a program of refracs enhance production of those reserves?
Yes, it would.
What other methods are available to increase the production of known reserves from KPK's wells?
Enhanced oil recovery involving water or CO2 injection would promote higher production and greater reserves. And in the case of CO2 injection, it would put CO2 into the Shannon and Sussex formations instead of the atmosphere.
Thank you. Has KPK analyzed specifically whether CO2 injection makes sense for the spindle field wells?
We have, and we've discussed the possibility of a grant-funded CO2 project with the Department of Energy. DOE has been supportive of such a project, particularly because utilization of CO2 that would otherwise be released in the atmosphere would be put into the ground.
And has that information been provided to the ECMC with your Form 3 submission?
Yes, it's part of the confidential business information that we provided.
And that was a document that was just shown by Mr. Killian on screen?
Right.
Thank you. Mr. Kaufman, why did KPK supplement its Form 3 submission in July of this year?
We learned that other operators had done so, and one had received conditional approval of its demonstrated costs after doing so. So we looked at doing something similar.
And when was this, do you recall?
We learned of Helena Resources submitting a plan and receiving conditional approval in July.
How did you go about supplementing your initial financial assurance plan, the Form 3 for almost 1,100 wells?
Ms. Clark will be testifying about that in more detail later, but essentially we decided to create subgroups of our wells using certain distinguishing factors, formation, depth, and came up with 18 different subgroups. Then we prepared a plug-in abandonment design for a specific well in each subgroup and then multiplied it out.
Thank you. And as you indicated, Ms. Clark will be testifying more specifically on that.
Yes.
Thank you. Mr. Kaufman, have you reviewed the exhibits and presentation slides of Frederick and Dacono in this docket?
Yes, I have.
What do you understand their primary concerns to be with respect to reclamation costs in particular?
Yeah, they appear to focus on reclamation acreages and topsoil acreages that are much greater than that need to be addressed by KPK at our locations.
Have you reviewed their assertions about much greater reclamation acreages needing to be addressed at KPK locations within their jurisdictional boundaries?
Yes, I have, and I strongly disagree with them.
What is or are the bases for your disagreement with those assertions?
They frequently indicate that facilities we do not own or don't have exclusive use of or responsibility for must be reclaimed, such as large portions of lease roads used by other operators, co-located wells and tank batteries of other operators, even irrigation ditch rider access roads, none of which we should or could even reclaim.
Okay. I'll ask Mr. Killian to bring up another screen share, if I may. This is some frames from, I believe, Exhibit S of this town of Frederick, I believe. Mr. Killian, if you could confirm that, please do so. Let's see. Yes, town of Frederick, Exhibit S. Do you recall seeing this exhibit, and does it illustrate the basis for your strong disagreement?
Yes, it does, and many other like it. So you can see long marked stretches of every road accessing our locations without regard to other operators' use or facilities. For example, the Gilson battery is co-located with a Crestone battery. The lease roads are shared with their wells. Some of these roads aren't our access roads. Down in the southwest quarter, the Longmont Farms 5 well, it has marked out the entire location. The vast majority of that is an oxy pad and an oxy tank battery. We don't have a tank battery there at all.
Thank you for that. And then let's go to the next image, Mr. Killian, if you would. How about this next diagram, also from that same exhibit for the town of Frederick, Exhibit S? Are your bases for disagreement about reclamation acreages also evident in this diagram, this aerial photo?
Yes, they are.
And can you elaborate?
Yeah, so for example, the Meredith battery that they have marked here is not our battery. That is also a co-located or even adjacent Crestone Peak battery, not our location. Some of the access roads here are the Ditch Riders Road, and so we wouldn't be allowed to reclaim that.
Thank you. Are there other assertions by the local government parties concerning reclamation to which you take exception?
Excuse me. Yes.
Elaborate.
So, excuse me, they seek expansive reclamation for locations that they also indicate are undergoing planning for near-term development. Surface owners and developers in these very communities have previously waived reclamation when surface development would undo the reclamation that their proposed increased financial assurance would secure.
Okay, thank you. Do you recall a surface owner that has previously waived reclamation for locations to be redeveloped in either of these municipalities, waived reclamation by KPK?
Yes, one of the witnesses for the town of Frederick, John Lee, has waived reclamation by KPK for his client, the special district that paid us to plug and abandon the well.
Who determined reclamation acreages in KPK's preparation of demonstrated costs, and specifically in the 18 designs, well designs provided with the supplementation package in July.
KPK's Vice President of Land, Avi Mailer, he prepared the acreages under my direction.
And do you understand his acreage calculations to be appropriate and excluding lease roads not used exclusively by KPK, as well as other operators or surface owners, equipment that you are not obligated or able to reclaim?
Yes, I think his acreage calculations are accurate.
Thank you very much. I have no further questions at this time. I reserve rebuttal testimony and redirect if necessary for Mr. Kaufman.
Okay, cross-examination opportunity for Mr. Boudreau.
Staff has no questions for Mr. Kaufman. Thank you, Mr. Chair.
Cross-examination opportunity for Mr. Sura.
Yes, yeah, thank you, Chair. And thank you, Mr. Kaufman. Is it true that your what you have put forward in the supplemental information did not include any costs associated with topsoil?
That's not true.
Okay, can you point us to where that topsoil is calculated?
Would need the exhibits. There are these, there's a whole spreadsheet. It's laid out. You can see each line item. There are, cost buckets. And very similar to Helena Resources, we used a spreadsheet and listed them out.
And you've taken exception to a number of the lease roads, and understand that. You didn't have the same concerns about flow lines, did you?
That we
That
remove them?
that the inclusion of flow lines is going to increase the amount of surface acreage that needs to be reclaimed.
I disagree. We included it in our abandonment expense. It's in the per well calculation and not the location calculation, but it is included.
In the acreage calculation, it's included.
I mean, the removal of flow lines typically is pulling the flow line out, not disturbing a tremendous amount of acreage. So.
And would you agree that a lot of your flow lines are fiberglass, and pulling them out like that is very difficult, isn't it?
It's a mix.
Yeah, thank you.
Mr. Lewis Prescott.
Thank you, Chair. Good afternoon, Mr. Kaufman. Following up Mr. Sir's questions, let's look at the cost breakdown for one of KPK's wells. I believe this is it. All right, can you see that?
Yeah.
All right, I'm just wondering where there's a line item for this page or the next page here. For example, the cost of topsoil.
It's in the categories at the bottom there, roustabout services. You have these categories of other services, as well as seed, soil, skid steer, tractor, cultivator. All of that is the reclamation expense.
Yeah, I'm not seeing anything for the actual cost of topsoil though. Where's that? Which bucket?
I mean, that's, as I just said, in the other services and included in some of the seeding calculations. Yes, I'll stick with that.
So is your position looking at seed that topsoil costs $1,750,000 an acre, and that's in addition to seed?
I don't think it's as cut and dry as you're trying to make it. A lot of our sites are not like some of the oxy pads you see, or or Crestone pads you see where they're built up with, tremendous road-based material. A lot of them are simple, small locations that don't have, they have disturbed topsoil where you have to rip and seed, but there isn't.
So you don't use heavy equipment on your well beds for facilities?
Well, that's why I said rip. The ripping part would be, and what the farmers will do as well. Ripping, disking, decompacts the soil.
So when KPK reclaims, it doesn't actually bring any topsoil on?
I didn't say that.
All right, let's move on. Are you familiar with what a jib is?
I am.
What's a jib?
It's a joint interest bill or billing.
And does KPK send jibs to its working interest partners?
We do.
Would it show operating costs?
Yes.
Would it show plugging costs?
Yes. Typically you would AFE for plugging costs as well, but
Okay. What about reclamation costs?
sure.
Would it show workover costs,
Sure.
shut-in costs, shut-in maintenance costs? I'm sorry.
General maintenance, yes.
Okay. So if the commission wanted to understand KPK's well expenses and actual plugging costs, KPK could provide jibs for the past 3 years or AFEs, correct?
Yes, if we have working interest owners in the well.
Okay. And let's go to some of the things you discussed. For example, future uses for these wells. You talked about refracking them. How much does that cost?
Oh, that depends, and I would have to research it.
Okay. You talked about enhanced oil recovery operations. How much does that cost?
I can't give that kind of number offhand. I'm sorry.
Has KBK done either of those things in the past few years?
Yes, we have. We've done refracts, and we have done. We have some enhanced oil recovery projects running. That said, we're talking about the spindle field, I believe, and those costs can vary depending on well design and formation.
Have you done any of those in the spindle field?
We have in the past, yes.
You don't remember the cost though?
I don't remember the cost.
Okay. You talked about CO2 injection. What's the cost of that for a well?
That
Well, I'm just trying to understand. You're talking about the potential benefits of these wells, and I'm just trying to understand whether they're financially realistic.
I can tell you they are financially realistic.
Okay, but we don't know what the actual cost is. We just hear you saying that you can do it. Okay, and with CO2 injection, don't you need pipelines going to each well?
Yes.
Okay. How much does it cost to install those pipelines? Any idea?
We could come up with these estimates for sure, but not offhand like this. I'm sorry.
Okay, what about getting local government permits to change the use of these wells and get pipelines through their jurisdictions? Have you thought about that?
Yes.
Okay. Have you thought about how long that process is going to take?
I don't know if I'm the right person to ask for. I'm not intimately familiar with the permitting process through local governments, but maybe we could.
Okay, when does KBK think that they'll be injecting CO2 into these wells?
It is a project that we have engineered, that we have contemplated. But we are not down the path of physical execution. And it is something that we certainly are interested in and proceeding with.
And you talked a little bit about access roads. Is it KBK's position that has no access roads that need to be reclaimed?
No.
Thank you, Mr. Kaufman. No more questions.
All right, at this point, this witness is available for questions from commissioners. And then following that, Mr. Jacobs will give you a chance for redirect. Commissioner Cross.
Thank you, Mr. Chair, and thank you, Mr. Kaufman, for your testimony today. The first thing I want to do is go back to some of the questions that Mr. Lewis Prescott was asking about, because I do think that some of these questions are important to understand as part of this overall application. The first is you talked about when you send JIBs out to working interest owners, that will likely have some information on shared costs with respect to reclamation, with respect to plugging and abandoning, etc. And you said it depends on if we have working interest owners. Can you give us an idea of your 1,209 wells in Colorado? How many have working interest owners?
We have very few working interest owners. Actually, we have gone through great effort over many decades to buy out any working interest owners that are out there. So very few.
So it's very few, 10%, 1%, less than 1%?
Oh, offhand, I don't know. I'd have to ask our VP of land, but very few, for sure.
And to confirm, none of those JIBs were submitted as part of the demonstrated costs to ECMC.
The JIBs weren't, but our actual invoices were.
The invoices that would include the same information as contained in the JIBs.
Correct.
So it wasn't the Helena or Helena resources information.
Well, that was our initial submission. Our supplemental submission, we based off of Helena resources. Submission, I suppose.
Okay. And one of the things that, and I realize part of this is going past what was asked about in the direct, but one of the things I want to try and understand, and I don't know if it's better with you or with one of the other witnesses, is to get an understanding of the financial capability. And I think this was partially touched on with some of Mr. Lewis Prescott's questions, but when we talk about the low producing wells under the commission's rules, them being designated as low producing, you talked about the fact that there still is a lot of reserves for you, for KP Kaufman to continue to produce. But you said part of the utilizing these reserves is going to be a matter of refracking, of using enhanced oil recovery and other processes to get this going. Can you provide us any kind of detail of if there's ongoing plans for this? Because we also have the counter side of this being, there's a lot of discussion that we've had in other instances where KP Kaufman is talking about selling assets and the difficulty in selling assets and telling the court that you can't come up with sufficient funds to post a bond. So the disconnect, at least on this commissioner's side, is how can you say you don't have money to post a bond, yet you do have financial capability to do enhanced oil recovery. You do have the financial capability to refrac wells to keep things moving.
So I think there are two questions there. To answer the first question, the numbers that I gave you are our primary recovery, what has been analyzed by petroleum engineers as primary, not as enhanced oil recovery, not for enhanced oil recovery. That is different, and that is, so
So enhanced oil recovery would greatly increase those reserves, recoverable reserves. And we have been exploring DOE grants for the enhanced oil recovery piece with CO2 injection, which the DOE has been very interested in. So yes, part of our funding for that would be through DOE grants.
So the financial capability of continuing to do enhanced oil recovery through the CO2 is based on potential DOE funding.
Amongst other sources, potentially.
What other sources?
There are parties that are interested in CO2 EOR and CO2 sequestration. So as we do in private enterprise, we explore different capital sources, and
but that sequestration is going to be separate from the enhanced oil recovery. That's the next step after you get.
That would be.
So you don't have these other parties providing money for the enhanced oil recovery at this point in time. You're talking about potentially other companies doing the sequestration.
No, that's not what I said. What I said was that they are interested in one or both. But there was an or in there. So it's not that they're only interested in sequestration. There are absolutely parties that are interested in EOR.
So kind of getting to the last part of what I wanted to look at is if we take judicial notice of what the district court said and what KP Coppin represented to the district court in its appeal of the prior hearing that came before us with respect to the CPA, KP Coppin indicated that they weren't going to be able to put forward a $600,000 bond. Is that correct?
We had testimony about the difficulty of obtaining bonding.
So if KP Coppin was going to have difficulty putting forth a $600,000 bond with respect to the CPA, is there going to be similar difficulty putting forward a larger bond than the $600,000 for the financial assurance here?
They're for different purposes. Sureties, or have different requirements for different types of things. It all depends.
So and I see Mr. Jacobs has raised his hand here as well. And I guess one of the things that I'm hoping to try and elicit, as this is one of the things that the applicant has to demonstrate here, is the financial capability of KP Coppin to meet its obligations. And so again, as I said earlier, I don't know if this is best done through you as a witness or through one of the other witnesses, but what I'm trying to do is get an understanding of KP Coppin's ability to meet those financial obligations. So far, what I've heard in your testimony is we have reserves, and there's likely some people interested in enhanced oil recovery. But we're also getting the other side of things where we're talking about, we may not be able to get a $600,000 bond. And well, this is a different security. And I'm just looking for some kind of clarification, some kind of edification, so we as commissioners can check that box that you as an applicant have demonstrated the financial capability to meet these obligations.
Understandable.
If I may, Mr. Chair and Mr. Commissioner.
Go ahead, Mr. Jacobs.
I'm concerned that this kind of gets us into the form of financial assurance, not the amount. This line of questioning and salvage value and security interests in our equipment being an acceptable form of financial assurance, as we previously discussed and as you ruled, we were going to leave those issues for a separate 701B hearing that we intend to petition for. We're certainly more than capable of answering questions on the amount of financial assurance and on the single well financial assurance with demonstrated costs that has been recommended for your approval by the director. I think this line of questioning regarding the form of financial assurance kind of gets us across the line between those hearings.
Well, I'll be honest, Mr. Chair, I think that may be a problem for me moving forward, because I think part of what we're doing, if we're going to approve a Form 3 financial assurance plan here, as requested by the applicant, is trying to understand that they do have that financial capability.
AG Davenport, do you want to visualize? And thank you.
Yes, pardon me. I didn't actually hear an objection from Mr. Jacobs. I heard a concern raised, and so I guess I'd like to clarify KPK's position on that line of questioning.
I'm trying to be respectful of the latitude afforded commissioners in questioning witnesses in these proceedings. But if you need an objection, I'll make one. I believe the commission has previously ruled that the form of financial assurance will be heard in a separate hearing, and therefore salvage value, security interests are off the table for this proceeding. And I believe Commissioner Cross, respectfully, Commissioner Cross's line of questioning gets into the form financial assurance that will be raised and vetted and deliberated upon in that separate 701B hearing. That is my objection.
And I guess I just say AG Davenport, I think without going into, testimony about what the salvage value is, just based on the objection, it sounds like KPK is indicating their only way to meet their financial obligations is through a salvage value. And ultimately, if we're trying to approve as requested a Form 3 financial assurance plan today without going into the form of it, I need to have some sort of comfort that they do have the financial capability. And so if that's only done with the salvage value, I think we may have a whole nother issue.
Do you want to continue in this line of questioning, Commissioner Cross? I understand the point you're making.
I think that I can ask some other questions and kind of go into some other details if that's easier. But that's the biggest question I have with respect to that issue.
Commissioner McGowan?
Thank you, Mr. Chair. I want to make sure that I'm understanding the conversation here, and I apologize because I'm not a lawyer. But if I understanding that if this commission comes up with a magical number for financial assurance, that is KPK saying the decision to submit something within 90 days is put on hold until the commission addresses whether or not salvage or personal property or whatever can be part of the financial assurance payment? I just want to make sure I'm understanding.
No,
Because
I'm of the opinion that if we render an order with a magic number of what the financial assurance is, they've got 90 days to post that number. Now,
Okay.
I think there is the opportunity to have a salvage value hearing as part of that, but the 90-day clock starts ticking, in my opinion.
Okay, thank you, Mr. Chair.
All right, Commissioner Cross, why don't you continue with another, whatever other line of questioning you want to go into, noting for the record that this issue remains.
Okay. We could, I want to try and look at the Form 3 that was submitted by KP Kaufman. And actually the document I pulled up was actually the financial assurance plan notice of decision, because it ultimately looks at the Form 3 that was filed by KP Kaufman. So I don't know if Mr. Killian, if you're able to pull up one of those documents, either the notice of decision or the initial application, the Form 3 app.
If I may, Mr. Killian, that would be ECMC Exhibit 2. excuse me, 3 is the notice of decision. Supplementary, do you want the initial or the
The
supplemental?
effective, I think the effective March 23rd is fine. I just want to talk about some of the numbers that are looked at within the Form 3 that was submitted.
Can you see that, Mr. Commissioner?
Yes, I can. And Mr. Kaufman, did you review this as it was submitted?
I am familiar with it.
Okay, and if we could go to, I guess before we go to it, did you hear Deputy Director Cuthbertson's testimony about the different aspects of what's being reviewed in this initial, the 702, 703, 704?
Most of it.
Okay, and I guess my first question is it your understanding that the financial assurance that's being approved will cover only 702, or is it your opinion that the financial assurance is going to cover 702, 703, and 704?
I might be the wrong person to ask here, but my understanding is it's 702.
Okay, and part of where I want to go is if you can go to, I believe it would be the 3rd page on this. So the other financial assurance aspects of it. This is where we'd get into some of the 703 and 704. Is that correct?
I'm sorry, I'm not familiar with that level of detail.
So 704 being the surface owner, and in the other financial assurance, it says amount of statewide blanket surface owner protection bond, $100,000. And the second bullet point under financial service says financial service for centralized E&P waste management facilities, $30,000.
Oh, okay.
Below the $30,000 for the E&P waste management, it says remediation projects with financial assurance, and that says 0. And then the next one says amount of financial assurance for remediation projects is 0. Is that correct?
That's what this says.
So is it your understanding that financial assurance will later have to include any kind of remediation for financial assurance?
I understand from Deputy Director Cuthbertson's testimony that I appreciate his explanation of it, that is a separate issue.
And is it your understanding that will be done on a case-by-case basis for financial assurance, or is that going to be something larger?
To be honest, I don't know.
Okay, I'll probably try that with another witness then. That's all my questions for now.
Okay, at this point, we have opportunity for other questions for this witness. Commissioner McGowan.
Thank you, Mr. Chair. And maybe Mr. Jacobs and Mr. Kaufman can tell me if I want to ask about the representative list, the presumptive list, and how it got put together, and just kind of what your thoughts were when you did that. Is Mr. Kaufman the appropriate person, or your other witness?
If I may.
You can go ahead, Mr. Jacobs.
Thank you. Commissioner McGowan. Mr. Kaufman worked with our other witness, Ms. Clark, who will follow him in testifying for us. But he does have some understanding of those 18 exemplar wells. So if you wish to ask him some questions, I'd suggest he simply answer what he can and defer the rest to Ms. Clark.
Great. You know, the chart is just like some colored bars and then some description of the wells. There's a lot of reading material, and I would appreciate maybe a more in-depth discussion around how you came up with those 18 wells. Are they all your wells? And how you used, is it Helena's financial assurance model to create this supplemental submittal?
Well, certainly Ms. Clark can give you more detail here, but high level, the 18 wells and why we came up with 18 is because there are 18 distinct cases with the combination of formations and depth and the number of wells into a tank battery. So, you know, we have some where, okay, there's one well to one tank battery, but we have some where there are dozens of wells into one tank battery. And so the reclamation cost of that tank battery would be divided out amongst the dozens of wells instead of the one well. So, you know, you have those groups, and then they are, you know, that example well is then multiplied out by the number of wells that are applicable to that group. And I'm sorry, I don't remember the other part of the question. I apologize.
So are these costs that the cost to P&A are in these different categories? Did you borrow them from the Helena model to come? So based on testimony from Deputy Director Cuthbertson, if I understood correctly, your original submittal, which was based on actual costs, I think he said didn't pass the LAF test. So you all came back and said, well, here's a model that a different operator used. We'll use that model. Obviously, those costs are different. And so I'm wondering how you came up with those updated costs.
I could lodge a minor objection, Mr. Chairman. And with all due respect, Commissioner, I believe the record will reflect that Mr. Cuthbertson's prior testimony was that the initial financial assurance plan submitted by KPK was insufficient. And the only time he said didn't pass a test, it was didn't pass a red face test. And that was applying $100,000 of reclamation to a small well in an agricultural field like KPK's wells.
My apologies, and I'm happy to reset the question based on what you just said.
Okay, go for it.
So, yes, initially we had submitted our actual costs with KPK performing the work. Staff was not satisfied with our costs. And so we saw Helena's conditional approval and their submission, and we did something similar. So a very similar analysis, similar breakdown of costs, and similar costs. So staff had noted that that we should use vendor costs, outside vendor costs, third-party costs, as if, you know, the orphan well program would have to, you know, in the unlikely event that they would have to perform the P&A and reclamation, what would those costs look like? And that's what Helena did, and so that's what we modeled our analysis after, with very similar, you know, arm's length third-party costs and scope.
Thank you.
Thank you.
Further questions? Commissioner Ackerman?
Thanks, Mr. Chair, and thank you, Mr. Kaufman, for being here with us today. Same question that I asked staff, and don't know if you have this information off the top of your head or if it's easy for you to get it to us, but can you tell us how many wells you've P&A'd and reclaimed in the past few years and what the average demonstrated real cost of those actions would be on a per well basis?
Off the top of my head, that is difficult, but we can produce those numbers. I will say that the actual number of P&A wells is greater than what was stated by, I don't know, in Dacono or Frederick's presentation. I think we plugged somewhat 14 wells last year. off the top of my head, I wouldn't be able to tell you those costs, but we could produce that. I will say that that was part of our original Form 3 submittal. We did produce those invoices and those costs.
Thank you, Mr. Kaufman. I certainly would be interested in seeing those things. And while those might not be the entirety of all reclamation costs, because they don't generally include roads, if those roads are still being used and maybe some other things, they should give us a pretty good idea. How does KPK rectify the assertion that KPK has recently represented certain recent P&A reclamation costs to be more in the 50,000 to 70,000 range, as per the materials that I think I've seen from the local governments?
Those are private agreements. There are, other factors that do factor into the costs that we discuss with developers, and it includes more than just P&A. We are giving up certain rights, we're giving up access, and so it's not apples to apples, I suppose.
Thanks, Mr. Kaufman. That kind of leads into my next question, which is I heard, and I think it was in an opening statement, and Mr. Jacobs can correct me if I'm wrong there. So it wasn't testimony, but I heard in this hearing that an insinuation that Dacono's intent might be to avoid developers having to plug wells. And I'm wondering if you can expand on that. Does KPK count on subsequent land users to P&A its wells? Has it done so in the past? And is the assertion true that KPK demands private payment in the order of $250,000 from subsequent landowners to plug a single well? Can you shed some light on that for us?
Sure. So no, we have plugged plenty of wells voluntarily. I think we plugged a number this year that don't involve any sort of agreement, and they were at what we determined to be the end of their useful life, and so we have plugged them. So certainly not solely relying on others. The wells that we do plug to accommodate development, it again is not just reimbursement of the P&A costs. We are giving up access rights to our property, reserves, and other factors, and they're private agreements that we enter into to accommodate the developer. Some of them want us to relocate lines to accommodate their development. We are happy to have those discussions and figure out what makes sense.
Thank you, Mr. Kaufman. And I understand that those can be a well by well basis and agreement by agreement basis. Could you shed light on the assertion specifically that have you been paid an amount of money in that order of magnitude in order to plug and abandon and reclaim a well?
We have had agreements in that order of magnitude, but again, it's more than just P&A and reclamation. It is relinquishing our surface rights. It's relinquishing the access to our minerals there, and the reserves. So there's more to it.
Understood. Thank you, Mr. Kaufman. And I heard some testimony, I believe it was you just a little while ago, discussing, again, subsequent surface use plans. And then in some instances, you were being encouraged to plug and abandon wells that you didn't intend to plug and abandon. And there was an assertion that, that developers wanted you to do that and might be better for them to be responsible for it. If I'm couching that wrong, you can let me know. But is KPK asserting that some subsequent surface use plans might relieve it from some of its P&A and reclamation responsibilities?
Ultimately, no. But if the question is, for example, I believe Frederick in their slides that they provided, that they have yet to present, they have plats of eminent development. And then they claim that we have to reclaim, significant portions of roads that also go to other wells. In the past, certainly, if a developer approaches us to accommodate their development and P&A our wells, by and large comes with, they are developing that property, they're paving over roads, they're putting in homes, and there's simply no need to perform the reclamation part because the land use is changing and the reclamation would be pointless.
Thank you, Mr. Kaufman. So as I understand it then, and I'll restate, but your testimony is that you fully assume all P&A and reclamation responsibilities, but except for in situations where a subsequent developer may be developing and it might not make sense to reclaim, but that in that case, sometimes you accept significant payment from that developer in order to move things along.
Yes.
Okay. Thank you. No further questions, Mr. Chair. I would, though, make a statement that I agree with Commissioner Cross that I do think that, an assessment of overall financial capability is an important component to us being able to approve a financial assurance plan.
Thank you. Okay. So Mr. Kaufman, you were asked by Commissioner Ackerman, I thought it's a legit question. What are the costs on P&A-ing? You said you P&A'd 14 in the past year. You said you didn't know off the top of your head, but you could produce those numbers. I would encourage you to produce those numbers tomorrow morning when we bring you back. And I also would encourage you to look at some of the private agreements and come back with some understanding for us to learn from you. What was the P&A component of that versus what are the monetary components for giving up the private rights and whatever else you want to do? I'd like more than just it's a jumble. So if you could be ready to come back and speak to that as well, I would appreciate that as well. It is 5 o'clock. I'm inclined to call the hearing for the evening. Mr. Jacobs, are you good if we not allow redirect this afternoon, but come back, have Mr. Kaufman on the stand briefly for a couple of those questions, maybe some follow-up, and then redirect and then continue with your case?
I am, Mr. Chairman, and I would just add that connection with your last recommendation to my client, Mr. Kaufman, that some of that detail will likely be provided by our next witness, Ms. Clark, but we'll have that information for you in the morning.
And that's perfectly fine. Whomever is the appropriate witness for that additional backup, I think would be very helpful.
Thank you. That's all I needed.
All right. Commissioners, if everybody's good with it, I would suggest we adjourn this afternoon. We're going to reconvene at 9 a.m. We've set aside all of tomorrow for this hearing as well. I had some other things on my docket that I'm going to have to clear because I think we're going to be here most of the day tomorrow. So with that, A.G. Davenport, do I need to do anything further? Do we need to motion to adjourn until 9 a.m. tomorrow morning?
Yes, Mr. Chair, motion to adjourn until 9 a.m. tomorrow morning.
So encouraged.
So moved.
Second.
Motion and a second. And with that, all those in favor of the motion signify by saying aye. Aye. Any opposed? Thank you. We'll see everybody tomorrow morning at 9 a.m.
Thank you.